Tomorrow. Yes.
Your Lordship, I appear of respondent numbers 3 and 4.
Lordship, I'm also appearing on behalf of respondent number 4, item number 1.
I seeking for a short passover of 5 minutes. My advocate on record is coming with the notes.
Only written notes of argument to be filed by the Narendrapur College. We have
5 minutes, Your
submitted
Lordship.
on the last occasion. They took time, my lord. And Lordship was kind enough to fix this matter today at the outset. Because, my lord, the things are continuing in a fashion.
Let him come 5 minutes.
Any specific time, my lord?
No. 5 minutes. You wait.
5 minutes.
5 minutes. Otherwise, yeah.
Number 2.
2. Very good. Yes, Mr. Barry. Have you brought the judgment?
They referred this MAT number in that order while joining the petitioner. On the basis of the order passed by the division bench, they have already, this is the documents. Can you see? They have already confirmed the service of the applicant up to 60 years. This is the memo.
2010 ওটা কি হচ্ছে 2010 No proposition has been laid down in this two judgments.
It was simply referred to the director for consideration and it was considered.
Yes.
And they have confirmed the service up to 60 years.
Each case has to be decided on its own facts.
Yes.
Case has to be decided on its own facts.
Actually, why you claim that the engagement of the petitioner is not lawful? Engagement of the petitioner was not proper. Why?
There are two things, my lord. The first thing is your lordship will find and we consider page 62, my lord, the reasoning portion of the recent order.
Okay, you tell the fact, tell the reason, why it's the reason. 62 years. Had the submission and the answer.
And on scrutiny of official document, I have the opinion that in spite of dated 4th March 2016, the attendance of Srimati Kompa Haldar till 5th September is purely arbitrary and against the letter and spirit of the said memo. As the memo was issued on 4th March 2016 and communicated thereafter, it is being ordered to disburse the remaining 2 months regulation, that is February 2016 and March 2016. But so far, this regulation parts, I shall inform my lord that our service was terminated, and thereafter, my lord, we continue, my lord, with the personal arrangement with the school. State was not responsible, and subsequent order, I shall show your lordship that has not been, my lord, quashed. The second part, my lord, the district project officer said that regarding confirmation of service till attaining the age of 60 years, the matter is under consideration subject to final outcome of MAT 25 of 2020 and MAT 26 of 2020 pending before the Honorable High Court at Calcutta. Those two, because that was the impediment before the district project officer. So now, my lord, those two appeals were considered in, and my lord, the matter was referred to the state project director. He considered this. Now, your lordship, my lord, today there is no impediment.
Yes.
There is no appeal. Yes. Now, your lordship can direct or straightway, my lord, pass an order considering this decision taken by SPD, my lord, has fallen from your lordship. Or your lordship can direct the SPD, my lord, to which I have submitted, my lord, on the last occasion, that SPD may take a decision in the light of his earlier order.
Now, why decision?
You
On other,
there
Why?
can be a mandamus, my lord. There is no problem.
rather you are taking advantage of this.
Yes,
That court generally, I stated on that date, court generally does not want to encroach upon the business of the administration. Court will not run administration. They will run their administration. If anything, any situation happens requiring the intervention of the court, court will intervene.
absolutely.
Interfere or intervene, but
My lord, if the
it
authority
is not
fail to
court's
intervene-
duty to run their administration.
Absolutely.
But as and when the matter is remitted back, you are taking advantage of it and you are going to stuck your own earlier decision.
My lord, the highest officer. of-
Again, you are forcing the person to file another writ petition. It is going on.
No, that cannot be. But the
But
one
you-
law laid down by the court is binding upon the administration.
My lord, may I suggest this?
Actually, in most of the cases, when question of facts involved, then the matter is remitted. The court can interpret the law and remitted the matter. This law interpretation will be guideline. You consider the fact of this case involved in
On this kind.
and consider. But they will start. Here, Uttam Kumar Noskar judgment I saw on that day. Most probably the problem started that 50% of the female. 50% post was fixed. It was reserved for the female candidate.
No.
No, that is
That was
another
not the issue.
separate case, my lord.
Huh?
Issue was,
My lord, he was appointed, she was appointed, my lord, subsequent to 9th June 2010 memorandum. That is the cut-off date.
But the
But in-
selection process was started in
Yes.
2004.
That is why, my lord, this issue is covered by your lordship's judgment.
Yes.
Yes.
Have you brought this judgment?
No, my lord.
It
My lord,
is
I can, my lord,
reported.
if your lordship fix it at 2 p.m., my lord, I can,
Yes.
that is Shahara, my lord.
Whether any
My lord, either Shahana
circular-
Begum or Shahara Parveen.
any circular, what is to be done if the legislature wants to issue a circular and affect the pending action? What would be the nature of the language
My lord,
and whether the nature of the language is sufficient in the notification dated
9th June 2010.
9th June 2010 to affect the pending action?
My lord, they are omitting one word. In the June 2010 circular, it was stated no new engagement of para teacher. They are repeatedly hiding that word new. But it's not at all a new engagement.
In that judgment,
Yes.
I got the occasion to deal with the issue and I
My lord,
interpret that the insertion of the word new
Yes.
presupposes existence of something old.
Yes. Yes.
my lord,
New
he-
means, that means whether it will touch the old one, it is to be considered.
Yes.
Okay, I am passing the order.
My lord.
The
Regarding the
present
salary,
petition has been
regarding
My
the
lord,
salary,
regarding the salary, my lord, I will request your lordship that, my lord, your lordship has also observed that it is a disputed question of fact and court, my lord, should not, my lord, go
but-
into those aspects.
My lord-
Your lordship kindly, my lord, refer the high office of the, my lord, state project director or any officer.
We want salary, area salary for the period of February 2016 to 5th September 2016.
yes.
My lord, February
My lord,
2016 and March
I will invite-
2016,
I
that
will
has been
invite your
paid.
lordship
Kindly
kindly-
see page 63. That has been paid.
March, that means now the dispute lies from March to September.
my lord, April to September.
April to September.
Now, my lord, April to September, my lord, I tell you, lordship, may I, my lord, place 2, 3.
Yes,
my
yes.
lord. Your lordship kindly consider page 33 once, my lord.
Yes.
Sir, this is, my lord, issued by the district project officer. It's bit illegible, my lord. Kindly consider the first paragraph, last 4 lines. The undersigned, my lord, in the middle, my lord, has your lordship.
Yes, undersigned.
Undersigned has to inform him that her engagement as a para teacher at such and such Vidya Mandir, district South 24 Parganas, is not considered for continuation as a para teacher in the said school. Consequently, he or she is not eligible for online regulation for DLE. Therefore, my lord, it was discontinued on 4th of March 2016. Now, my lord, and my lord, your lordship will find from page 33, it was forwarded, serial number 4, to the petitioner. Now, my lord, kindly consider the next page, that is, my lord, an order passed by this honorable court, page, the order dated 10th November 2016. My lord, kindly consider page 35. This order was challenged. Now,
Yes.
in the third line, in that view of the matter, the order impugned passed by the said project officer is set aside and the said authority is directed to pass a fresh reasoned order after giving an opportunity of hearing to the petitioner. And the petitioner will be entitled to rely on documents in favor of her claim as a para teacher within the period of 4 weeks from the date of communication of
Yes.
this order. After
Yes.
now, my lord, this order doesn't say anything about his reinstatement or arrear salary. So only direction which was passed by the coordinate bench of this honorable court, my lord, to consider her case. Now, my lord, the issue was considered at page 37.
Yes.
My lord, kindly consider this is an order dated 15 December 2016, paragraph 5. The engagement of para teacher of Muldia Chaitanyapur Durgapur Vidya Mandir was not considered by the district level committee. This is not relevant. Order. The subsequent paragraph. In the present 2 cases, the Honorable Justice has directed the undersigned to take a decision whether the petitioners were duly engaged on 13th May 2010 as para teachers of the school or not. From the submitted papers, it is crystal clear that both the petitioners joined at Muldia Chaitanyapur such and such Vidya Mandir as para teachers on 4th of October 2010. So the petitioners were not duly engaged on 13th May 2010 as para teachers at Muldia Chaitanyapur Durga Vidya Mandir. All concerned may be accordingly. Now, this was again challenged. That is at page 39. A judgment and order dated 19 July 2017. Relevant, your lordship will find at page 40.
Yes.
On the second paragraph, the impugned order was passed pursuant to the direction of this court in its order dated 10th November 2016, passed in WP such and such. Hence, I cannot say that the impugned order is perverse as it decided the fact referred to the DPO by this court. However, it is also true that the aforesaid division bench order and the circular dated 16 November 2010 were not considered by the DPO, perhaps because the same were not placed before him. Therefore, my lord, the issue was remanded. Here also, my lord, this prayer was not made that I worked for such and such period. And now today, my lord, your lordship kindly see, the first order, my lord, says termination of her service. Now, rightly, wrongly, my lord, she was terminated. Therefore, my lord, she is not supposed to discharge any duty pursuant to that order when it was passed in March 2010. Thereafter, it was challenged. When it was challenged, my lord, no prayer was made that kindly give me arrear salary because I discharge my work. Nothing. Only, my lord, the order was quashed and, my lord, referred to the DPO for a fresh consideration. When the DPO, my lord, found that now this is her appointment is illegal, my lord, he rejected the claim of the petitioner. There also, my lord, no prayer was made from the order that she asked for her arrear salary. Now, in this order, my lord, which is at page 39, my lord, your lordship will find that the order passed by the DPO was not touched. It was not declared as a perverse one. It was not quashed. Only thing, my lord, this honorable court found that certain documents were not considered. That is why, my lord, the issue was remanded back to the DPO for a fresh consideration. That was the only issue. I am not, my lord, troubling your lordship with the subsequent events, but nowhere at any point of time, this issue of, my lord, discharging duties from April to September was raised before this honorable court, and for the first time this is being raised. That is why, my lord, I am saying, my lord, this If your lordship at all thinks that yes, this issue is required to be considered, then my lord, I will beseech your
You,
lordship.
Mr. Bari, forego.
Why, my lord?
Forego.
It is on record that the record produced by the state itself. Kindly see the.
But I
No,
do
no,
not
no,
know
but
what said.
Mr. Bari, Mr. Bari,
Let him
actually
complete.
record says you worked up to February 2016.
5th September 2016, I worked. It is on record. Well, that is
Okay, that issue would be referred to.
Yes.
kindly hear me.
That would be referred
Let him
to.
complete.
Attendant register is to be consulted.
Kindly say one line reply. Let him complete. Let him complete.
He is
They are-
completed. You
Malad,
just
they are saying everything.
Mr. Roy Mukherjee is vocal about your demand of area salary.
Malad, the unfortunate part is he is nowhere responsible for releasing the salary. He is representing such a respondent. He is nowhere responsible for releasing the salary. This is
Yes.
unfortunate.
But it comes from my fund. Paschim Bongo
Okay.
Kindly say, Malad, once. Only about one reply. First of all, my learned friend failed to show any documents that my service was ever terminated.
Yes.
Last occasion, I have shown your lordship was also the no, this is not a termination at all. Secondly, kindly the report filed by the state in the kindly see the ones the report filed the state. State has filed the report. Kindly see once.
What they have stated in the
Filed by the respondent number 3. That is state authority.
yes.
Who is responsible for releasing the salary matter?
What they have stated.
Kindly see they have annexed the attendance register. They collected the attendance register from the school and they have annexed the attendance register. Kindly see the attendance register. Third teacher Pompa Haldar.
March,
Third teacher Pompa Haldar. Kindly see at last page, September 2016 up to 5th September I worked. It is their documents, not my documents.
Okay. Okay, Ashu.
May I just give a short answer to this, my lord? My lord, first thing is,
There will be no reply of a reply,
no.
madam.
Clearly
Yes, it
says,
cannot be a
page
reply of a
33,
reply.
my lord, I have already shown that our service was discontinued. Specifically stated, our service was discontinued. My lord.
But fact remains he rendered service.
My lord, that rendering service, my lord, with the arrangement of the school, my lord, cannot be, my lord, legal in the eye of law. This is a public money after all, my lord. We have to, my lord, we are answerable to the higher authorities, the central government, my lord, how we are disbursing our funds. A person, my lord, has not discharged, my lord, duties after 4th March 2016 cannot entitle to get salary. And this issue was never raised before this honorable court. Time and again petitions were filed. That issue was never raised.
And what will be the effect of illegal termination of the petitioner for last 5 years? Last 5-6 years he could not discharge her duty. Who will responsible to him? They will release the salary for the same.
Without discharging duty, he is entitled to single paisa
Who is responsible, my lord?
There are 3 occasions in which petition was filed.
Let them compensate for the same, my lord. For the 5 years.
Let them go to the civil court.
But the debarred me from performing a duty without any reason, my lord. Every time they are every time, my lord.
The present petition is an offshoot
Number one.
Oh, Dashapati, yes, you give your written argument.
Yes, Your Lordship. Sir, Your Lordship, I've annexed all the relevant cases.
Did our notice short, but we've just, for your lordship's convenience, we put the cases together. So that's why it may look a little bad.
Okay.
And my lord, we'll serve it. My advocate on record will serve it on my learned friends.
Okay. The written notes of argument as submitted on behalf of respondent number
3 and 4.
We have taken out application for substitution of the petitioner number 1.
where is your beef?
Difficulty is today I am handicraft, not have.
এই অ্যাপ্লিকেশনটা রেকর্ডে এসছে
Well, there are two applications, I tell your lordship, CAN 2 and CAN 3. CAN 2, my lord, was filed for substitution, but it was out of time. So, my lord, there was a direction by this honorable court to file a separate application. We have filed a separate application, CAN 3. Lord, your lordship kindly allows the both the applications, my lord, and thereafter, my lord, we can amend the cost title, my lord, and the matter can be heard out.
আচ্ছা আপনি করুন এই দুটোই ক্যান 3 কি করে হয় ও ক্যান 3 2005 এটা একটা 2001 ক্যান 2 টা কয় এসছে ক্যান 2 অফ 2025
CAN 2 is of 20.
2003 হবে মোস্ট প্রবাবলি
2023.
2003
CAN 2 of 2023
পেয়েছি
CAN 3 of
2025.
2025.
আচ্ছা
This is with respect to the petitioner number 1.
আচ্ছা নিন ক্যান আপনি আসুন ক্যান 3 Item number 4, not today.
This is the fourth time.
Lordship,
accommodation
the
has been
senior
sought-
counsel who is
sought
leading,
on behalf of the petitioner, my lord.
senior
Every day
counsel
coming
who is leading me is in court number 16, your lordship. He's in the between.
Who is the senior counsel?
Abhijit Rai, sir.
Huh?
Abhijit Rai.
My lord, this
Lordship, tomorrow, lordship.
So এটা আপনি আর দেবেন না লিস্ট পুরো থাক।
Lordship, tomorrow, lordship.
Not according to your dictation, sir.
Every day I'm coming, matter is on the top.
Okay.
Lordship, then a few
You
minutes
have
pass
to
over.
follow the court's procedure.
Lordship,
Court is not to follow your procedure.
only 10
Sir.
minutes pass over, lordship.
Okay. No,
Not even pass
এই
over.
ম্যাটারটা ইয়ে হবে না। আচ্ছা।
My
Pick
lord,
the paper, the private
Yes.
respondent, my lord.
in compliance of your lordship's order passed on last occasion, I have served the copy along with the downloaded copy of your to the private
এটা
respondent.
কি এটা মোশন তো?
She am for the respondent. Transfer call.
Due to non-consideration of representation, my lord. The page number 28 onwards. Petitioner applied for Jalodhara scheme. Petitioner was directed by the state respondent to approach the private respondent, Jalodhara facilitator. Accordingly, my lord, kindly see my lord, page number 21. Quotation was.
I heard this matter most probably. What happened? You recapitulate that.
Petitioner applied for Jalodhara scheme.
জলধারা scheme.
Jalodhara scheme for purchasing fully mechanized steel boat from the Jalodhara facilitator, approved facilitator. Kindly, my lord, kindly come to page number 21 of the writ petition, my lord. Private respondent placed the quotation. Petitioner accepted that quotation and placed the work order. Accordingly, my lord, make advance. Page number 22, my lord, 1 lakh. This one is my lord, money receipt issued by the private respondent. My lord, page number 23, annexure P4. My application was approved and my lord, subsidy was directly credited to the private respondent. Subsequently, my lord, petitioner paid further sum of rupees 1 lakh. Page number, my lord, 24,
Yes.
24th May 2028. Total 3 lakhs, my lord. Thereafter, my lord,
1 lakh, 1 lakh, 2 lakh.
2 lakhs plus my lord, subsidy 1 lakh directly credited to the private respondent's account. The
Oh,
government. Total 3 lakhs, my lord.
1 lakh, page 23. It was directly credited in the account of the
Private respondent.
vendor.
Vendor.
In the account of the vendor who needs supply such board.
Fine.
Uh,
Thereafter, my lord, 1 lakh.
Raj Kishan, Radha Kishan, Mittal and Company.
Company.
Okay. Thereafter, you made
Further
payment 24, 1 lakh.
1 lakh.
Therefore, 2 lakhs.
2 lakhs plus subsidy 1 lakhs from the government. Subsequently, I have been denied subsidy. Jalodhara scheme was, my lord, for financial assistance to the, my lord, ferry service operator.
Subsequently, what happened?
My lord, thereafter, private respondent denied to deliver the fully mechanized boat on account of, my lord, escalation of price instead of total
On account of
escalation of
price, yes.
boat. They demanded 24 lakhs instead of 14 lakhs.
Instead of
14 lakhs. Kindly see page number, my lord, quotation, page number, my lord, 21. 14 lakhs 25,000. Total 14 lakhs 25,000.
yes.
13 lakhs 25 and my lord, canopy, my lord. That means, my lord, cover of that steel made vessel, my lord, 1 lakh, total 14 lakhs 25. They
Yes.
demanded 24 lakhs. Subsequently, my lord, denied to petitioner was denied to deliver that fully mechanized boat. Petitioner made representation first, my lord, on, my lord, page number 25, annexure 6, 25th March 2029. That was not considered. Subsequently, my lord, series of representation to the state respondent
Annexure, my lord, P8, page number 28, running page number 28 onwards, my lord. Hence, before your lordship, seeking consideration of the representation by the state respondent. My lord, state respondent being the administrator of the Jalodhara scheme may resolve the dispute between the facilitator and my lord petitioner beneficiary of the Jalodhara scheme. They did not
Yes.
consider that.
You are appealing for?
I am
Private
seeking refund
respondent.
of that amount.
Your
So
lordship,
why are you not giving,
They have acknowledged,
refunding the money?
My lord, kindly come to page 21.
Yes.
My lord, the third paragraph, there is written taking 30% of the order value as advance. Balance amount.
What? Payment? 30% of the order value at advance and balance amount at the time of delivery. Guaranteed 12 months.
30% amount, and they are supposing that 3 lakhs were deposited, but the fact is they pay only 2 lakhs. The subsidy amount, my lord, comes
After the amount credited in your account?
come to page number 23.
What? Page 23?
Page 23, my lord, third paragraph. Accordingly, you are requested to contact the concerned governor and to complete the following process. Enter into an agreement, any bank or NBFC, if required, for getting financial assistance to purchase the vehicle, deposit part of the project cost as initial down payment to the governor sector as usually available. This was the part payment. After this, after the provisional sanction, they have to again apply a form 6 to the department by including these 2 documents. Then after we were supposed to get the 1 lakh subsidy amount, which they never came to agreement with us. They never placed and work order. They never placed that.
Okay, you treat the transaction cancel.
they are
Can you withhold the amount and enjoy the benefit therefrom?
My lord, the amount which they paid, we already initiated the work. We have to structure the diagram of the boat. We already purchased the engine gearbox. We have all the documents with us. I received this yesterday only. I shall come up with the affidavit in opposition. Kindly grant me some time.
Okay, you give your bank account. That means now you only to get the money you are saying that I done something. Unless and until agreement is completed, who gave you authority to do anything
there is
with this money? Who give you the authority to utilize the money? No agreement.
After the quotation,
No agreement. Give the answer to the query first. There was no agreement. So unless there is no agreement, you cannot claim that I have already taken step. I have already invested certain amount of money. That please will not be available to you, because the agreement has at all not been concluded. There cannot be any concluded contact in between you and such and such. So unless there is a concluded contact, you cannot utilize the money.
But there is no correspondence at all from
It
the
was just an advance. It was just an advance. Thereafter, no agreement. So there is no transaction except acceptance of an advance from a person concerned who is intended to run his boat. Except this, in the eye of law, there is nothing. Now you are only to enjoy the amount. Only you are taking this plea. I have done, upon receipt, I have done such and such thing. I have done such and such thing. It's a ploy.
I shall file my affidavit in opposition, my lord. Kindly
Why, if I think it that the affidavit is required, court will invite. I can do the affidavit, but you give your account. The same shall be attached.
I shall produce.
Account in which bank all your transaction, commercial transaction is taken place. Through which bank?
Okay, my lord, by cash.
That amount will be attached.
By cash, my lord.
Or I am directing you are for the state.
No, Your Lordship, I'm led by Mr. Tarok Karan and he's facing some medical issues, Your Lordship. I'm praying for not today only.
Okay, come here. You declare blacklisted. You declare him blacklisted, otherwise court will declare. Okay. Either you give your client, either you refund back the money, 2 lakhs, okay. Regarding 1 lakh, you take the issue with the government. But it is a private citizen one. He, with a legitimate expectation that certain amount of subsidy will be given to me, and I shall arrange the boat in this way. Initially, you raise the amount, you claim the amount 14 lakhs and 25,000. Subsequently, from their letters, it is appearing that you started claiming the amount of 24 lakhs.
Never demanded 24 lakhs, my lord. Let them show any.
Okay, so admittedly that there was no concluded contract. Now you of your own, you are taking a plea that on receipt of such advance amount, I done such and such thing. And hence you will not be able to get any money.
Yeah.
And now you will ask, that is civil dispute. Ask them to go to the civil dispute.
Let them pay the
Ah.
remaining balance. We will deliver the boat, my lord.
You give your details of your bank account, okay, and you come with the extension. Ask Mr. Karan what step you have taken against him. Because since 2018, this person is enjoying. That means today is 7 years. Had the money was kept in an account, it would fetch almost double. You said what step you have taken? Because the entire process was initiated by you, the state. You ask a citizen that if you can do such and such, I will assist you so that you can introduce a ferry service over any river. Ganga, where? Ganga.
At Petuaghat.
Hmm?
Petuaghat.
So you take instruction. When? Next week? Next week. Okay, আপনি whether Mr. Karan is in court today?
Grateful, Lordship.
I'm developing.
Yes.
Number 6.
I am for the petition.
In this matter, I'm for the state matter laid by
On the
Alice City.
last occasion, Mala, your lordship directed me to serve the copy. Lord petitioner is an senior citizen. He is a lady.
That is on the basis of ACCC 2011, so that the Pradhan Mantri Awas Yojana.
We made an application.
Whether they will give or not, it is their discretion.
My only submission before you,
You
Lord.
are for the state.
Let it be
Consider.
Let it be considered because I have fulfilled the criteria.
Okay. Fulfill the criteria of the notification. Any
Yes.
notification is there. Where is that?
Yes, this is my lord. Your lordship kindly say, my lord, page 47. 37.
Page 37. Here.
Page 37.
Citing inaction on the part of the concerned
Appearing on behalf of respondent number 3, 4, and 5. I'm led by Senior Advocate Mr. Lokhi Kumar Gupta. He is suffering through a severe illness. I'm praying for 1 week adjournment.
My lord, yes, my lord, we cannot. In our seniors, my lord, if he is not well, we cannot, my lord, object in any way. Your lordship kindly then fixes it up in, my lord, August. Yes, in August, 2nd, 3rd August. My lord, this is otherwise ready. And my lord, my learned senior friend from Union of India doesn't want to exchange an affidavit. 1 and 2. 1 and 2.
আচ্ছা ये लिखুন an adjournment has been paid for on behalf of respondent number
Hard and
Item number 10.
Lord, I am for the petitioner. Your Lordship. This matter relates to
I'm for respondent secondary board, your lordship.
the provocation of illegal suspension order against the 20 years experience of headmaster, who, my lord, suspended on the basis of the perverse, my lord, order passed by the board, my lord, when the matter is sub judice before the honorable court, and when the report submitted by the DI, that report was against that report, my lord, is Higher School Commission of School Education has given a clean sheet to the headmaster. Kindly have a look. The suspension order.
May I submit first? My lord, now the suspension
I am
period
the
gone.
petitioner. Shall I
No,
submit?
let me see. He was
No. I am the petitioner. I shall
maybe,
submit.
but
No.
what submission
This
is
my-
being
Oh,
done?
okay.
This has get
He
the
has
advantage from
challenged
the.
the order of suspension. Now, my lord, the charge sheet issued. Thereafter, a final inquiry done. Board has taken a decision. He has sent a show cause notice. Well, Padvas, that will be proved before the court.
Totally
Board,
perverse.
there's a show cause notice issued.
That is why you have
Ordered.
before my
Show
submission.
cause has been passed by the president of the board, asking him to show cause.
final order of punishment.
My lord, show cause issued, did not reply.
But kindly see.
Charge sheet issued, did not reply. Thereafter, inquiry officer, IOPO issued, inquiry was held by the DI. He never appeared before the inquiry officer, did not participate. Thereafter, your lordship, the president of the board of not the final order, is a final order of show cause, asking him that why he should not be made a compulsory retirement. Show cause notice, this show cause of final was issued on August 2024. 3 times this notice was sent to him, even to his learned advocate also.
But till
date, no reply. So, my lord, this writ petition, he has challenged the suspension. That period has gone long back because DP has been come to the conclusion. So, my lord, if he has to challenge, he will have to challenge this final notice of this final notice.
They want to force free.
This does not remain. That stage has passed. Thereafter, there were several repetition appeal preferred by him before the court. 2 or 3 appeals, my lord. I don't remember this man to have all dismissed.
All dismissed.
2 appeal challenging.
Challenging show cause. All appeal challenging show cause. But the interesting part, your lordship, the show cause was the suspension was done on January 2024.
Without hearing me, my lord.
My lord, there is no provision. There is no provision that while suspending a teacher, my lord,
The very
hearing is to be
totally
given.
perverse, my lord.
Oh, okay, yeah. Whether it is perverse is
Why I am saying
Why he did not participate
a
in the
decision.
let me submit first.
He did not participate in the proceeding. Why he did not participate? If it is a
Let me
perverse
submit
one,
first. This is
several
my lord.
notice
This is a biased report of the DI, a defunct report, and that report was null and void by the Commission of School Education.
Go.
Can you see this?
He can file a report before the honorable
Can you
court.
see this, my lord?
Okay. Actually, he is saying that whether this petition is maintainable or could be entertained further or not.
Law at the stage.
You challenge a so cause notice. But what he wants to say, kindly understand. Here, not only making submission, you have to, I understood what is the stand of the respondent as well as what is the mind of the court. You have to go on reading, okay, while making submission. He is saying that there was some subsequent development after issuance of the so cause notice.
No, suspension order.
So cause notice was issued.
Suspension order is bad, my lord. Bismillah, God.
Whether
What is he saying?
Whether it is bad,
suspension order is illegal. Why? Though that is no question of discipline proceeding, that is no question of any type of headmaster. Suspension is totally perverse. Kindly see this, Lord. When the matter is pending before the Honorable High Court, before the single judge, then the board has suspended the headmaster.
But there is no
without taking leave from the court.
There
He's
is
more
no
than
bar.
court. He's more than court, my lord.
Suspension was
What they have
done on direction of the honorable court.
don't try to give that emotional.
Suspension
No,
was
my
done
lord. Kindly see this. Kindly see this. This is the court. I have come before the temple of justice. I have come before the temple of justice. What is going on this year? Well, kindly see this suspension order first. 13 page.
The stage has gone. Disciplinary proceeding concluded. He will have to challenge the order.
So you file affidavit to bring all those documents.
Lordship.
Yes, my lord.
I am inviting affidavit.
Lordship.
Because
that is their claiming. No, lordship. That is their claiming because headmaster will retire in the month of December. That is their one. They are
what can be done?
They are forcefully
ask you trying to go back or ask him to move.
Well, there is a
The
final
process of giving instruction to you, it is completed in your chamber. Okay. Here, I shall not allow you to open your chamber again.
Ignorance of the client, my lord, that he has come actually. That is his ignorance. Well, kindly see, my lord, first 313 page. The order of
he was
suspension.
arrested. He was there.
After coming to learn that some subsequent development has taken place, whether shutting the eyes to those development or to subsequent fact, whether it can be the dispute can be resolved effectively. You give answer.
The suspension order is bad.
You challenge one affair. Subsequently,
I have
charge is
challenged the
submitted.
suspension order.
A trial concluded.
So your lordship.
Trial concluded. Now the court held you
bad.
conviction.
Thing is
You are
bad,
guilty of the offense.
in the eye of law.
Now you are guilty of the offense. Now you say why I shall
kindly see.
You will not allow the court to say.
Well, kindly, my lord, kindly go through the page 313, my lord. I have challenged the suspension order.
How can
without hearing me, they are submitting.
But that has
What's happening, my lord? This is
difficulty.
nothing to say.
What is the procedure?
We can
Kindly
come up with affidavit along with the board. Very sorry. Is consecutively, my lord, serving notice upon him all the notice refused. He preferred not to appear.
The learned advocate also, my lord, that also no reply. My lord, the final order of the final order, the board has taken a decision of compulsory retirement. So, my lord, board cannot issue a final order without giving a chance to him, a show cause. So, my lord, that show cause notice to him was issued in August 2024. Thereafter, 4 times this notice was sent to him, even to his learned advocate. But like no reply, they're just sitting tight over the matter. And now he's coming and challenging this suspension. This is gone. Now, if he is aggrieved, then he'll have to challenge this show cause notice or the final order which board is going to take. Neither is challenged. Subsequent, there was charge sheet file. So he could have come and challenged the charge sheet. He sat tight over it, never replied to the charge sheet. Therefore, the inquiry officer appointed, inquiry officer called him before the inquiry. He could have gone over there, whatever grievances he had, he could have said over there, my lord, but he did not participate.
So, whether you will bring such subsequent fact by filing supplementary affidavit?
Yes, Lord.
Huh?
He will
So come,
with the, my lord.
We shall ask them to come with the comprehensive affidavit.
Yes.
That would be proper. And I don't want to say anything. You will get the a disciplinary proceedings has 3 parts.
There is no question of disciplinary proceeding, my lord.
That the authority
What
can
is that
decide.
suspension order is bad, my lord.
What is the basic?
My
suspension order, my lord.
It is a bad what said. My second submission, second sentence could have benefited you.
One after another has been.
A disciplinary proceedings has a 3 parts. First is the initiation. Second, the inquiry. Last, the punishment.
Yes. Now it has reached the stage of punishment.
Now you have challenge. Your challenge is confined to that initiation of the proceedings.
That is
your submission suggests. Your submission says, hey, yeah, you will take you from me.
Entire thing is that I have challenged, my lord. And division bench has
you file supplementary affidavit.
Division bench says
you file supplementary affidavit being those subsequent facts on records. You don't think that so cause notice is the basis of all subsequent events. Here, you are not listening to the court. You are thinking from this thinking that so cause notice is the basis of all. Since if I succeed to get the so cause notice quashed, everything will go. No. It is the charge sheet which can be set to the actual initiation of the disciplinary proceeding. Even the authority finds that yes, your so cause notice or reply is satisfactory.
Yes.
I shall not initiate any proceedings.
Lordship.
Proceedings is dropped. I shall not do anything. Your reply is satisfactory.
Not reply.
When he will find, when the authority will find that your reply to the so cause notice is unsatisfactory, then we'll proceed and issue charge sheet.
And he has not replied at all.
Okay. So now you don't think that I shall succeed, I would be succeed to get the so cause notice set aside and I shall be saved. Not that.
I do not challenge the so cause notice. I have challenged the order of
come to pay.
Where is challenge of suspension?
Can 13 minutes please kindly go through 13 minutes. You will understand. Entire thing is
okay.
Perverse, my lord.
Oh, okay.
Can you see, my lord? Go through for a moment.
Okay, now whether at this present moment it can be held that suspension order is bad. Order of suspension. Why order of suspension is passed? Tell. You have challenged the suspension order. Why? What is the reason behind placing one employee under suspension? Why in contemplation of a disciplinary proceedings? You say.
I think they will
Tell.
They will give the reply better than me.
No.
We are saying
you are challenging.
You
are challenging.
They will reply than me. That is why
that is the problem.
They have issued this.
We don't want to enter into the room.
They have issued this suspension order.
Inquiry
suspension order is issued so that during inquiry proceedings, the concerned employee, delinquent employee, cannot get access to the document and the witness and can tamper it. Suppose you have manipulated one document and misappropriate certain fund. If I allow you to come,
that is not.
if I allow
the audit report, man, can you go through this?
If I allow you to come in the office daily,
Yes, we open every each and everything. What has been done?
one day we'll take out the file
C of the
and we'll
suspension.
remove.
Kindly 6C of the suspension.
He's the headmaster.
No.
All the documents.
You are the custodians of all documents.
6C is the, kindly see this, my lord.
So I do not find any justification to set aside the order of suspension.
That is
And my lord,
Then you just suspension, I can enter into the particulars, data, suspension date, such and such. According to your submission, you say why suspension order was got.
Suspension was passed on the basis of that.
They were contemplating.
6C say, if there is a reason to believe that unless the concerned teaching and non-teaching staff suspended, it may result in tampering on destruction of evidence or concerned teacher and Baski. So, shono na baba, shono amake submission korte dao. But a concerned teacher and non-teaching staff may cause undue influence and discipline proceedings pending and contemplated.
Yes.
Well, this is on the basis of 6C.
It is the way.
But subject to correction and lawsuits, what happened here?
just what has fallen from your lordship, that is.
আমাকে বলতে দাও না বাবা, তোমরা তো
Nothing new will come. Nothing new will come.
But kindly see, my lord, what happened actually. Headmaster filed a writ petition before the High Court that some teachers are running parallel administration in the school.
Oh, Justice Chakraborty, my lord, it was rejected by your lordship. Over
That
there.
single judge keep his matter pending and given related to file another.
And my lord, and the
Ah,
second
yeah.
part of prayer A, it is completely.
Whether you will
What is praying?
whether will you bring the subsequent fact or subsequent document on record by way of filing supplementary affidavit, or I shall invite them and I shall invite them to if now you consider if now I hold that yes, order of suspension was bad, allow him to join. What benefit we will get?
Come, my lord.
They have already concluded the proceedings.
Yes.
They are issued a second SOCOS notice.
No. Final order.
Why
Final
not
order.
have come,
Court
lord?
has taken a decision
No,
of
headmaster
final
will retire in the month of
compulsory
December.
retirement. And
Headmaster will retire in the month of December. It does
Why the
notice, Shokas has been sent for him to reply.
Yes, suspension order.
it is like a second SOCOS notice.
Yeah,
Or it is like a second SOCOS notice. Why?
Such action.
Actually, disciplinary authority in some circumstances proposed a punishment.
Yes.
I shall dismiss you.
That stage it is.
The record says I shall dismiss you. I am issuing a SOCOS. You will give answer why I shall not dismiss you.
But no reply given.
Okay, it is called SOCOS notice. Although unless the rule says mandatory, it cannot be stated to be mandatory. That notice, that means everything concluded. Now, if I say that yes, suspension order is bad, you ask him to join, what benefit you will get?
No, my lord, I am not want to.
Today this order will pass, tomorrow they will issue the final order.
Because what happened actually, headmaster will retire in the month of December. That is why suspension order, my lord, this is totally more perverse order.
Discipline
So
proceeding.
so this suspension order before his retirement. That is why I have come. It does not mean I should go to I join once again in the school. That is not my
How we
desire.
So why are you challenging the suspension order?
Suspension order.
Suspension order, that means they have deprived your right to what? They have snatched away your right to what? They have placed you under suspension. They have paid subsistence allowance, but they have snatched away your right to work. You will not be able to attend the work. In some circumstances, some cases, he said you will attend. You will give your signature, the attendance in that room and go back. Okay, now if the order of suspension is declared bad or illegal by this court, what benefit you will get? Rather you wait. Let them pass the order of compulsory retirement. Then you will raise this issue.
Lordship, that is
That initiation was bad. Okay. And if you can succeed to quash all the thing, then you will may get the back wages. Suspension means first 3 months 50%, thereafter 75%. That means 25% is the difference. If we get that he need to be reinstated with back wages, he will get everything. So file supplementary. Supplementary will be all the documents.
Supplementary will repeat with regard to Milord.
I shall say it would be better for you to bring even the order, let them pass the order, final order. You bring the final order. Otherwise, another supplementary epidemic. Or you can withdraw the same, taking liberty to challenge the final order if passed in the meantime.
Yeah, never participate in any proceeding, never
avoid it.
Never reply to the charge sheet.
Kindly give me one supplementary epidemic, Milord.
Okay. Acha, at the outset, Mrs. Bhattacharya, learned advocate, representing the board,
The bank was supposed to give affidavit in opposition today. Your lordship was expect me to file a supplementary affidavit.
I am sending you, sending this matter to mediation. To mediation, you mediate the dispute, that would be proper. Okay, and everything did not require the judicial adjudication or yes. Sometimes some matters is required mediation and local adalat also.
He is not here. Bank is not appearing. Kindly adjourn the matter for the day. Mr. Achievement.
For that is adjourned for a period of 2 weeks. Acha, 1 week. 1 week. Yeah, next. Let the matter appear under the heading for orders 1 week hence. As paid for on behalf of the petitioner could. Let the matters appear under the heading for orders 1 week hence. Means.
Item number 8.
Yes.
8 I am for the petition.
That matter. So I can recall that matter on that date. Whether the assistant head.
Just before that, I just remind your lordship. Your lordship kindly turn to page 53.
Page
53. Entire fixation, chronological, the date wise, that was given at the time of retirement. Just your lordship kindly see serial number 1. Serial number 1. This is the part 2.
Yes.
Left hand side assistant teacher. He joined 21st September 1988. His pay fixation start 500. Now your lordship kindly turn to serial number 23. Next page. 23.
23, yes.
He joined as assistant headmaster.
Yes.
Middle portion, his pay was fixed 8575. Change in the
additional increment as per GO dated such and such. 2000.
Now just melody you can see. The shortcut করে দিচ্ছি. You also kindly see that GO. 180. That is the GO 185. That is mentioned also for May 2000. That GO was issued under ROPA 98. Whether under ROPA 98, one assistant teacher join as assistant headmaster will be entitled one additional increment, not 3%, on additional increment. You will also see that GO second page. You will also see that GO second page. You will also.
Yes.
This is 185. This was issued first page. This was issued consequent upon revision of pay under ROPA 98. That is the 25 ACV, 12 first page. First page melody. First page.
Yes.
185 GO, 4th May 2000.
Yes, consequent upon.
Consequent upon ROPA 98. 25 ACB dated 12 February 1990.
Yes, ROPA
98. You will also kindly see next page.
Yes.
Next page, this is the category of teachers. Your lordship will consider serial Roman 3.
Yes.
Roman 3. One additional increment in the revised pay scale. This is applicable. One additional increment after from assistant teacher to assistant headmaster, he was granted one additional increment. That your lordship will find serial number 23.
Yes.
And your lordship kindly see. Then your lordship kindly serial number 23. Just prior to that, serial number 22.
22, yes.
8325, 8575.
Yes.
Only 250 rupees was given. You'll also kindly minus only
yes,
250.
Yes.
250 only was given, not 3% additional income. Only 250 rupees.
And additional.
For taking responsibility as assistant master. That is the GO has been given.
Yes.
Now you'll also kindly turn to serial number 33.
Serial number?
Page 54 on that page, serial number 33.
36.
33.
33, yes.
He joined as headmaster. 1st October 2008. They have disputed from that date.
Yes.
10,750.
Yes.
Right hand side, join as headmaster. 10 class high school. Not my lord, the higher secondary school, 3% additional increment. That is not the case here. He joined as headmaster in a secondary school. When joined? 1st October 2008. His fixation was done under unrevised, not ROPA 2009.
10,750.
Your lordship just now, your lordship kindly see. This fixation was your lordship, just a moment. Your lordship kindly see. Headmaster. Yes. This page 34. It was revised under ROPA 2009 with retrospective effect from 1st January 2006. Because ROPA 2009 was given effect to from 1/1/2006. But when 1/1/2006, he was assistant headmaster, not headmaster. That is why, my lord, he is revised serial number 34, 22,710. Serial number 34. Just below, my lord, after the headmaster join.
Yes.
Right, left hand side, assistant headmaster. Your lordship, my lord, see next page, serial number 40.
Yes.
Serial number 40, his fixation revised under ROPA 2009 as headmaster 1st October 2008, 26,860.
Yes.
Prior to that, his fixation was 25,690.
Yes.
Serial number 39.
Yes.
After adding 3% additional increment. The lordship, my lord, kindly, my lord, the serial number 39 and 40.
Yes.
39, his pay was 25,690.
Yes.
1st October 2008, when he joined as headmaster, under ROPA 2009, his pay was 26,860, adding 3% additional increment in a secondary school. Whether he is entitled for this 3% additional increment after joining as headmaster in a secondary school or not, this is they have disputed. This fixation was done by the DI of schools. Well, the DI himself has approved, yes, you are entitled for 3% additional increment on the date of joining as headmaster, that is 1st October 2008.
Yes.
Also, kindly see, this is the ROPA. This is the ROPA 2009 and subsequent amendment. It is not applicable to this case. It is not the case that the school was accredited higher secondary school. He is entitled to 3%. This is not the case. He joined as headmaster in the secondary school, whether he is entitled for 3% additional increment or not. This is
Yes.
the only issue. I was granted by the DI. DI has approved. That is page 45. DI has himself approved. This is your fixation. This is in the year 2008. Onwards till the retirement, I have given my lord this fixation. Well, also can see ROPA. This is 46 ACB 27 February 2009.
Yes.
You will also kindly turn to see page 8.
Yes.
11, serial number 11, clause 11. Fixation of pay.
Page 8.
Page 8. 8 of my compilation.
Yes.
Clause 11. Fixation of pay on promotion. On or after first day of January 2006.
Yes.
The effective ROPA my lord 2006. In case of promotion from one grade to another, my lord I coming from an assistant headmaster to headmaster. In the revised pay structure, this is the ROPA. On or after 1st January 2006, my lord I joined 2008. Fixation of pay of an employee shall be made in the following manner, namely, A, one increment equal to 3% of the sum of the pay. One increment equal to 3% of the sum of the pay in the pay band and the existing grade pay shall be computed rounded up to the next multiple of 10. So 3%, that is the ROPA himself provided 3% increment on promotion one grade to another. You will also kindly turn to.
So whether headmaster or secondary school.
That is not the issue.
Another grade, promotion to another grade.
I assistant headmaster to headmaster. Under ROPA 2009, you will also kindly consider. Under ROPA 98, that GO, one additional increment was given only 250, not 3%. That is the after ROPA 98 when the assistant teacher to assistant headmaster. Now after revision of pay ROPA 2009, this 3% increment new concept to the given to those teachers one grade to another on promotion. You will also kindly see page 45 of my repetition. This is the my lord the EI himself. You will also kindly see fixation was done. I don't know whether it was correctly or not, because on the basis of which I was given pay salary. This is a page 45. You will also kindly see.
Yes, page 45.
Page 45. Serial number 5. Rate of joining 1st October 2008.
Yes.
6. Pay band applicable 9,000 to 4,500. Grade pay 5,400. Serial number 7. 1st October 2008. Right hand side 26,860. You also got it. Serial number 7 just below. What was the fixation? Add 3% increment excluding additional grade pay. Additional grade pay only 200 rupees. 25,690 minus 200. That is 770. 770 has been added to 21,400. That is equal to 26,860. That has been approved by the DI. DI also put in signature and his seal. You will also be at the bottom. Pay provisionally fixed 26,860 with effect from 1st October 2008. What's wrong with the fixation? I don't know, my lord. This is the entirely as per ROPA 2009. Clause 11 of ROPA 2009. This benefit was given to those employees who on promotion one grade to another. So there is no question, there is no relation between the fixation of ROPA 98 and ROPA 2009. ROPA 98 185 GO, that was one additional increment, only 250 rupees was given to me. after my lord, from the post of assistant teacher to assistant headmaster. So that fixation was done as per ROPA 98, not the ROPA 2009. Your lordship will my fixation, page 55. This is very interesting. Your lordship can see page 55 of my writ petition. My lord, the serial number 40, 26,860. Your lordship kindly see serial number 47.
Yes, I have already marked.
46, 32,330. 46. You also got it 46, serial number 46.
46, yes. I have given the difference.
32,330.
Yes.
47, school was upgraded. No increment. You also can see same 42,330. 30, 46, 47, same pay. Because you enjoyed one increment when you join as headmaster in secondary school. So school was upgraded to higher secondary school, you are not entitled. So this fixation is correctly done. Now the joint director of accounts overstep, my lord, of the DI's fixation that no, you are not entitled, you enjoyed one increment as per 185,452,000, so you are not entitled. I do not understand, my lord. Now, as per this fixation on the page 55, entire, my lord, I retired 31st July 2023, my 1,1007. This is the last pay drawn. Now, at the time of retirement, entire fixation has been refixed and reduced from 1st October 2008, and my lord, overdrawn has been calculated.
Yes.
So my submissions, my lord, regarding refund of amount, that is, my lord, your lordship's no Rofik Masi judgment. I, my lord, do not place my that should be refunded. And regarding fixation of pay scale,
you are forced to refund.
That is the under compulsion of before just after retirement, my lord, that has I have refund the amount. That is also division made, my lord, Kalisadhan Chatterjee, my lord, that has been held.
Rupees 5,90,000.
Yes, that has been refunded.
Okay.
And my lord, your lordship will find the pension payment order, page 126.
126. Yes.
My lord, the last page, your lordship can see just skip over 5 lines. 1,04,400. 126. Name Krishna Bandopadhyay. 1, 2, 3, 4. My lord, just last page.
1 lakh. 1,044,400.
That has been reduced from 1,10,700 to 1,04,400.
1,700 to 10,000. 10,000, 1,10,000?
10,700.
700. Okay.
1,04,400. And my lord, the overdrawn.
Okay, have you brought any judgment?
Yes, my lord, I will also kindly see, first of all, my lord's judgment.
Rofik must see your.
Corrected orderটা কি এখানে ছিল না?
Yes, you find out, yes, Mr. Chattopadhyay.
You will also kindly see, my lord, the Manoj Kumar Patra, my lord's delivered a judgment. This petitioner was also was the assistant headmaster, joined as headmaster, but in that case he joined as headmaster in the higher secondary school. That is why I claim for 3% additional.
3% additional.
Although he enjoyed till the date of retirement, overdrawn amount. And in another case, Mr. Boiswa submitted that no appeal has been preferred. They have accepted this judgment. That is also, my lord, this is and also relied Rofik Masi and others judgment. Yes, paragraph 3, petitioner comments his service career as an assistant teacher. He was subsequently appointed as assistant headmaster, and thereafter, my lord, he assumed charge as headmaster. The assistant headmaster to headmaster. This is the, my lord, the also is the same facts. And my lord, in the subsequent judgment in Monotos Pal, the submission was recorded. I have also instruction that that order has been complied with. They did not prefer an appeal. And submission of Mr. Boisho has been recorded that no appeal has been preferred. And also, my lord, the honorable division bench judgment that has been, my lord, the lordship, my lord, the citing those division bench judgment, this judgment has been delivered. 3%. Montos Palta দিচ্ছিলাম
মনোজ পত্র মনোজ কুমার পত্র
হ্যাঁ মনোজ কুমার পত্র ওইটাই
Yes, লিখুন। So, I'm passing order.
No, my lord. Kindly allow me to submit. My lord, was last occasion, my lord, I will place my lord, opposition. My lord was rightly my lord, pointed out that petitioner was appointed as assistant teacher on my lord 12/11/2002, and petitioner assistant headmistress, sorry, my lord 12th October November 2002, assistant headmistress. Then, my lord, she got additional increment of ₹250, and she was enjoyed, my lord, till my lord 6/10/2008, when she was appointed at headmistress. It is a fresh selection. My lord, my learned senior friend, my lord, showed to your lordship the my lord, the chart where from it appears
one grade to another. It is not merely for being additionally, rather one grade to another.
Thereafter, my lord, headmistress, she was from the date she resumed her duty as headmistress, she was enjoying two additional benefits. One for assistant headmistress, and subsequently for additional headmistress benefit. 3% benefit was she was allowed. If your lordship kindly have a look into the and see retired 2023. So dispute arose 2008 to 2023. She was enjoying two additional benefit, which is she was not allowed to. She was entitled to first assistant headmistress, and after that, when she joined as headmistress, she was only entitled to 3% benefit as headmistress. But two benefit was given erroneously by the that was wrong fixation done by the district inspector of school concerned. That was at the time of retirement, that was vetted to the joint director of accounts. It reveals page 129 that additional benefit what she enjoyed, that is to be refunded. 5,39,000 was refunded. I will show to your lordship the judgment of this honorable. Your lordship knows that the overdrawal amount cannot be deducted, and if deducted, that would be that is different question. But the wrong fixation should be corrected at the for fixation of her or his employee's pension. The division bench also passed judgment. If wrong is being done, that should not be allowed to continue. That should be her pay should be reduced accordingly. This,
but the money already deducted would be refunded.
That is here is two part. One is the overdrawal amounts 5 lakhs and odd, that she refunded, and another part is refixation of her pension. Admissible amount should be refixed. Her pension should be refixed on the basis of admissible, because her pay would be reduced from 6/10/2008 to 31st July 2023 date of return. At least 15 years she got two additional benefit. One should be corrected. That is the correct proposition of law. That is, my lord, if you are
According to Mr. Jana, there is no wrong fixation. He is saying that his plea is that the petitioner was for being assistant headmistress, he was given one additional increment. That is rupees 2050.
250.
250.
That is
It was subsequently discontinued. Subsequently, it was discontinued.
No, my lord, that was not discontinued.
As
Continue.
assistant headmistress, 250 was given as per government order dated 185 under ROPA 98.
Yes.
That was given to for being appointed as assistant headmasters. Assistant headmistress. Now, when she joined as headmistress under ROPA 2009, that is clause 11, she is entitled for 3% additional increment. So there is no the relation between that increment and 3% additional increment. And there is no the question of double increment. That fixation was done.
So whether you says whether journey from additional headmistress to the post of additional headmistress is one gate to another gate or not?
Certainly.
So one gate to another gate.
Yes.
So if one person completes a journey, then he will get an additional increment.
3%.
3%.
That is not disputed.
So being headmistress, he enjoyed the 3% benefit.
Along with 250, that was she was
that
allowed
fixation
to.
was done. That was
That was
over.
wrong.
That
But I am
wrong?
putting
That
question
was under
myself.
the GO
What is the cause of
185.
action of the writ petitioner?
That
What
was
is
the
the
GO
prayer?
185.
What is the prayer and cause of action of the writ petitioner before your lordship? What is the cause of action? He questioned the objection raised by the joint director of accounts. Why? Because DI fixed it wrongly. That has been checked by the joint director of accounts. That is totally separate wings. That is finance department. I think that joint director has not made a party here also.
And hence, initially, I wanted to make a question or query or clarification from both of you, whether one teacher who, after being an additional headmistress or headmaster, who has got the benefit of additional increment 250, he will be the payment of such benefit would be stopped when he would be headmaster.
Yes, because of the fresh selection.
You lordship kindly see, this is the ROPA benefit. This is not the no question of fixation, one increment or thereafter. ROPA 98, that benefit was extended to the assistant headmaster. Thereafter, ROPA 2009, one grade to another. This is the fix. That is why DI has approved. DI is the main disbursing authority.
That is wrong.
Joint director of accounts at the time of retirement, they say no, you will enjoy. Why I have enjoyed? I enjoyed as per ROPA 98, 185 GO. This is the government order. As per 185 GO, I was given to that increment. That is not the 3%. He said double increment, not double increment.
Yes, I have got your point. So, Mr. Chattopadhyay, you are claiming that the assistant headmaster, being an assistant headmaster, what one teacher was enjoying, he will not be allowed to enjoy such benefit when he will become a headmaster.
Yes.
So where is that rule notification? That is not mere claim of one director, secretary, such and such. You have to come with a specific rule.
I have July 185. Before that, kindly come to my opposition, page 4 on.
Yes, page 4.
I am related 185, which has been handed over to you.
Yes.
That is counter statement. On the petitioner was allowed increment for her service as assistant headmaster as prescribed in the memorandum of student.
I have not would not find your, if it is affidavit in reply, affidavit in opposition. Where is the affidavit opposition to Kutega? Where is the affidavit? Is Sobus part of the Bukhana? It was the affidavit. Have you submitted it?
Yes, last occasion, my lord was also relied upon my opposition.
দেখুন তো আবার ঢুকে যায়নি তো আবার একটা ওতে ঢুকে গেছিল। আচ্ছা, সেদিনকে একটা অর্ডার দিতে দিতে আমি একটা ইয়ে পেয়েছিলাম, এপিডিবিন ইন অপোজিশন, সেটা হাতে দিয়েছিলাম রিপ্লাই। বললাম না সেদিনকে একটা অন্য রেকর্ড থেকে একটা এপিডিবিন অপোজিশন, আমি তখন তো জানতাম না এটা কার, আমি ভেবেছিলাম যে একটা এপিডিবিন অপোজিশন সেই রেকর্ডে ঢুকে গেছে। এটা তো হাল খুব খারাপ। Have you got any spare copy?
That I have, my lord, the marked.
Oh, okay, give it what portion he wants to take. And hence the court wanted to answer this question, whether our clarification on this
Position,
question.
this has been nothing only than 185 GO has been cited and this fixation has been done. You will also ROPA 2009 clause 11. You will also once again, my lord, the clause 11, only when the revised pay structure, one increment equal to 3% of the sum of pay in the pay band and existing grade pay shall be computed. My lord, this is the, my lord, the ROPA 2009, this benefit has been extended to the increment. So when I joined as headmaster, what was the fixation? I was assistant teacher, I was assistant headmaster. That what was my fixation? That has been revised under ROPA 2009 with 3% additional increment because I joined as headmaster in under ROPA 2009.
Mr. Chattopadhyay, additional, the word additional means what he is getting. In addition thereto, he will get something.
But my lord, when she was appointed at headmistress, she was treated as assistant teacher, not assistant headmaster, because fresh selection, that headmaster post was not promotional post, that was separate selection conducted by the West Bengal School Service Commission. She applied and she was treated as assistant teacher, not assistant headmaster. She relinquished her, my lord, benefit of assistant headmistress. That benefit she relinquished.
Where is
Who
that?
will be promoted? That is
Certainly,
the,
because
Actually, you consider the court say he is claiming that there is a right fixation. You are claiming that no, there is a wrong fixation. Applying the proposition of Rafik Messi, direction can be given, you refund the amount. But the fixation cannot be stated to be bad, and he will get pension. Henceforth, he will get pension on the basis of that fixation. That means 1,04,000. It is your claim.
that is his claim.
His claim.
Fixation can be made. If
Yes.
there is no,
here, my
yes,
lord,
if there is a wrong, that can be done.
there is a confusion, my lord. TI is a, my lord, school education department, separate which fixed the pay, but the, my lord, accounts department is a totally different department. They have, my lord, accountant, they have checked it that you had enjoyed two benefits at a time. That is not, that is the
No, unless you come with a specific notification, specific government order or rule to snatch away that benefit, I shall not allow. Court cannot.
I am placing, my lord, 186, my lord, the 185, my lord, memorandum that was my lord, given to your lordship, my lord, 4C.
185.
Yes, just I have handed over. Yes, yes.
Ropa.
Yes, yes.
Yes.
4th May 2000.
Yeah. Ropa, you have 7th February 2000.
Ropa 2009. No, we prior to that, Arkadini. Another copy I have.
Yes,
Oh, no.
185.
Sorry,
185. Yes, 185.
sorry, man.
Oh, got it. 185. 185. Yes.
181, not 185. Sorry, 181.
181.
Yes.
181 is.
Also, my lord, this my compilation 181 there.
October 2009.
In the compilation, serial page 8.
8 October 2009. Yes, got it. 181.
My lord, got my opposition copy of the opposition. I have quoted it.
I mean, this.
Kindly come to my lord opposition first.
Okay, you said you have quoted, you show from this quoted clause.
Clause 4C. 4 subpara C.
Four
A, B,
subpara C, yes.
A, B, C.
Hey.
After coming, got it?
4B or C. C, yes, in case of extraordinary leave of 1 year.
So after coming,
Serial number, page 9 at the bottom.
Yes, after coming.
Next one.
Page 9 of the competitor.
Okay. It is kind of 4 লেখা clear. After coming under the revised pay structure, assistant teacher of government sponsored aided on her account to the will get his pay fixed in the pay structure of the
After coming under the revised pay structure, that is
After
2009.
Assistant teacher of the government sponsored government aided school on his her appointment to the post of headmaster, headmistress, or assistant headmistress will get his her pay fixed at first structure, getting one increment 3% existing basic pay, that is such and such, in addition to the grade pay of or additional grade pay as assemble or the post of
in addition.
Thereafter.
In addition to the gate pay, additional gate pay.
Thereafter.
As admissible or the post of headmaster, yes.
Additional increment
Hmm.
or appointment to the post of headmaster, headmistress, or assistant headmaster, headmistress, as was being allowed in the unrevised scale of pay, is discontinued from the date of coming into force of the revised pay structure, provided that those who already got additional increment before 1/1/2006 in the unrevised pay scale for his her appointment to the post of headmistress or assistant headmistress will get their pay fixed in the revised pay structure with effect from the date of option, by taking into account the additional increment already allowed to them. So, my lord, it would be, my lord, stopped when she was getting, my lord, pay fixed ROPA 2009. My lord, additional when she was allowed to get additional 3% interest under ROPA 2009.
Okay, I am fixing another date. What can be done? Today I thought it would be disposed of, but you also look into that point.
I have checked up, my lord. The entire fixation has been done by the DI as per ROPA 2009. What's wrong with the fixation, my lord? Now the joint director of accounts in the, my lord, the pension said.
If without arriving or jumping to the conclusion that what the DI has done as right and conclusive, let us check whether DI has done any wrong or whether subsequently director has done any wrong. Okay, let us all, three of us, let us check.
May I propose one thing, my lord? May I propose?
I heard the
May be relegated to the commissioner of school education, because he is the ultimate authority to
Upon exchange of affidavits, no question of relegation. Your lordship, my lord, heard this matter at least, my lord, 3 or 4 occasions. Your lordship, conclude the hearing.
Yes, but cannot be concluded today. Another date is, আর একটা ডেট দিয়ে দিন, স্পেশালি ফিক্স ম্যাটার করে একটা ডেট দিয়ে দিন, কবে ফাঁকা আছে। আর দ্য অর্ডার পাস করলো।
If there
Then
is
authorities-
fixation is wrong, I have accepted. But what is the wrong fixation? Let him satisfy the what is the wrong fixation.
Okay, heard the learned advocate appealing for the respective party leads the matter for solution. Whether I am again saying the teacher after being assistant teacher, what benefit he has received, whether that benefit shall not be extended to him when he will be a headmaster.
Actually, my lord, my learned friend is relying upon the fixation done by the DI. My lord, as per DI, my lord,
No, your learned friend is claiming that it is a journey from one gate to another gate, and hence he has got that benefit, and that benefit has merged with his pay scale. Accordingly, his pay has been revised, and what he has got as headmaster, that is additional.
I will show to your lordship, my lord, 181. I will explain it next day. My lord, that is not entitled. My lord, I will show.
Yes,
and
yes.
demonstrate.
You just assist, both of you assist on this.
Not one line.
হ্যাঁ?
আমি দিয়ে দেবো।
আছে ফাইলের মধ্যে আছে না
ফাইলটা দিন আমাকে দিন চেক করে নিই।
Okay, tomorrow at 12:30.
12:30.
Come.
12:30
12:30 না স্পেশালি ফিক্স ম্যাটার করে। না 12:30 টা করবেন নাকি না
Item number 116.
I am for the petitioner.
Who is for your other side?
On the other side, last occasions, paper time, and ultimately a belated opposition was filed. After taking a time, a short opposition filed, that I will do in my. The moot question is that the persons, those who are employed under employment of the government of West Bengal, কেন ভাই সারাচ্ছ? আরে বাবা দাঁড়াও না, মনে করছো তুমি কি জানো কোনটা কোথায় রেখেছি? তাহলে তুমি সরিয়ে দিচ্ছ, আমি কোথায় খুঁজে পাবো বলো? তাহলে the moot question is for regularization of the total vacant post is 481. They are acting as the supervisor. They were appointed by the notification dated 2008. Average more than 20 years. They are serving.
SWG and SC department means
Self-help group.
Led by Tapan Mukherjee is coming on his.
Self-help group and self-employment department.
Yes.
This is a department. In the case, very peculiar is that this same department, self-help group and self-employment department, they are seeking for our regularization. They are practically sympathetic that long service has been drawn by these contractual employees. Those initially appointed for a short period, thereafter continued. An ultimate effect for continuation has been given up to 60 years of age by a circular. So all these things, but the pay, why I have come up with this honorable court, the pay is about to be similar with that of the Group D employee. They are basically Group B because they are acting the same role, which I will explain later on, the Joint Block Development Officer. What happened initially, the PSC found that there are 481 number, 406 at that point of, was a regular vacant post of the supervisor. They created they made a circular, thereafter post could not be filled up within a span of time by the PSC. Because of the lack of the PSC, they expressed that within this short period of time, within these 2 years, we cannot fill up the vacant post of the supervisor. That is why on the same profile, rank and file, these persons were recruited under the contractual employment. I have, my lord, before making submission, already I have served the reply, I am filing it. Here, my lord, will appreciate the position of the supervisor. In short, my lord. বসো না, আমি তো বলবো তখন তো আসলেই বলতে আরম্ভ করছি, তুমি বসে নোট করে না। Here, initially, before this circular made in 2008, how this post was created, a short story has been given, page number 35. Page number 35 is that notification when this, in exercise of the power conferred on so and so, Governor is pleased to make the following amendments to the West Bengal rules. One is that policy formulation of cooperative all works pertaining to the self-help group, self-employment schemes operated by the departments of the state government. The matters in connection with related to the formulation and functioning of the Bangla Swanirbar Kormosongsthan Prokolpo, provisions of the skill development training, coordination of the institutional finance in connection with the self-help group and self-employment scheme. This scheme itself, this department itself created for the very purpose of, initially for BSKP. BSKP means Bangla Swanirbar Kormosongsthan Prokolpo. Thereafter, kindly appreciate a notification was made. Next page, page 36. The scheme shall be their notification for setting down what is the BSKP. BSKP is a public policy. BSKP is to provide help to unemployed youth for their vocational training and other things. Then applicability schemes, I will go by short submissions. The scheme shall be applicable to all eligible entrepreneurs individually or in group, subject to a minimum of 5 members and all of them belonging to the same area. Then other conditions, definitions, unemployed youth. Next page,
page number 37, Roman 6, I have marked unemployed youth. Then eligibility is there, who can apply under this scheme. This is not the supervisor's roles. This is for this purpose. Initially, this 481 number of vacancy was created and the self-employment department was created by 2006 notification. It is obviously with a holistic purpose this was created. Then funding patterns. Funding patterns is all coming from the government funding, government grant, implementation of the scheme. The PIC means Public Implementation Committee. It's 3 level. It will this particular scheme for BSKB will be effective in the 3 levels. One is PIC at block level. Second is PIC at municipality level, Kolkata Municipal Corporation, and other municipal areas. There shall be district level monitoring committee, so and so. This was the purpose of this very creation of the department itself. Self-help group and self-employment department was basically created initially for the BSKB. Thereafter, the PSC could not fill up this regular vacant post. Kindly come to page number 42. Yes. 42, my lord. Lordship will see. This is for a notification from the Principal Secretary addressed to the Director, SHG and SE, Director at Government of West Bengal. Here, the undersigned is directed to say the total 481 posts of supervisor, self-help group and self-employment as detailed above have so far been created in these 3 phases to cater the self-help groups in the place throughout the state. Now, several notifications have been mentioned and 481 post how it was created. I am on to show that the every post is sanctioned post, regular vacant post, and it was created as existing. There was a vacancy, not any irregular or I am poking my nose from the back door. It is not that.
But under a scheme.
Under a scheme, this regular vacancy was there, and then this was a PSC department which was ought to have taken steps. They could not. This was the direction upon the PSC. It has been brought to the notice of the government while filling up this post created in the first 2 phase. Reservation for the candidates belonging to so and so or was not mentioned so and so. Then now kindly come to paragraph 3. Under these circumstances, it has been declared that all the vacancies that may be available in the 481 supervisor, self-help group and self-employment should be advertised for direct recruitment, maintaining the model 100-point roster so and so, so that the process of scrutiny of the application interview can also be completed within a week. It was a direction upon the PS. The government department, that is the SHG department, was directed to recruit through PSC. But what is the outcome? Before our role to come as a supervisor on contractual basis, this was the initial intent of the department itself. There was a regular vacancy in the panel, and all these 481 vacancy was accorded with a proposal by the finance department. Then kindly come to page number 43.
Yes.
Just a minute. Now 43, it is a circular from Chief Secretary memo, it is rather Chief Secretary Government of West Bengal to District Magistrate. Here you are aware that the present manning of the office of the department self-employment at various levels is done in terms of the guidelines contained in so and so. Subsequent the issue of these guidelines, post of district self-help group and self-employment officer, supervisor, self-help group and self-employment, lower division clerk and group D staff also created in every district. This is dated, kindly consider dated 2009. After we came into this office, our recruitment, how we were recruited, I will show that document also. Then P and AR department of the state government is taking steps for filling up the vacant post of the district self-help and self-employment officer through posting of WBCS officers who will take charge of the district youth committee, who are now looking after the responsibilities of the self-help group and self-employment department at the district level. The district magistrate will exercise overall control and supervision over the functioning of the SHG and SE department in the district. He is requested to arrange suitable office accommodation for the district so-and-so office near to the office, collectorate building, till other arrangement would be made. Some support staff will also work in addition to their existing duties, may also be provided to the local arrangement till regular appointment is made by the SHG and SE department. In case of subdivision concern, subdivisional officer will be looking after the functioning of the self-help group and self-employment department. So it is very clear the district magistrate will be responsible for the district, and for the subdivision, the overall authority is the SDO, subdivisional officer.
And block level BDO.
Block level BDO. This was the very purpose. With this sanctity, we were recruited. Now kindly come to kindly give me 1 minute time. Just 2008 সার্কুলারটা কোথায় গেল? ওকে ডাকো তো। ওকে দেখাচ্ছিল, যেটা দেখাচ্ছিল তুমি ওকে ডাকো। মানে kindly give me 1 minute. One document is very required. মানে কোথায় গেল? তুমি যেটা দেখাচ্ছিলে 2008-এ, সেটা একটু আমাকে দেখাও। 2008 that will be taken care of along with the that is the order, my lord. He submitted, I am just my lord, he submitted that it is matter of tribunal to be decided. I submitted entire points with the merit at the time of considering the merit of the application, because I will show even this court has passed several judgments, one of which was passed in the recent time when the petition was moved directly against the departmental refusal against the contractual employment. Your lordship has passed the order, and there is very vividly will appear that there is no embargo, because if it is a state government employee, direct employee, if our service was established service, regular service, then we can approach the service tribunal. We are contractually employed. We are seeking for the regularization. No embargo. And other Supreme Court, High Court, one after one judgment have been passed. So that is why I requested your lordship, I made a prayer that at the time of considering the entire matter on merit, the maintainability point may be considered. And that has been recorded in the order. কোথায় গেল? কোথায় গেল? এই লোকটা কত নম্বর পাতা দেখিয়েছে? 2008-এর 2008-এর সার্কুলারটা দেখো, যে সার্কুলার তোমরা এলে রিক্রুটমেন্ট হয়েছে। হ্যাঁ, তোমাদের যেখানে শিক্ষাগত যোগ্যতা ভোগ্যতা হবে যেগুলো আছে, এটা এটা কি করে হবে? হ্যাঁ, kindly come to, I am very sorry, my lord, I could not find out this page. Page number 90 is the Government of West Bengal's notification to the is the memo to the district magistrate. After that, P9 is the P8 and P9.
This issue has never been raised, Mr. Mukherjee. No, this matter at the time of admission, it has not been taken. It is being taken at the final stage of hearing. Justice Mantha took up this matter in 2023. Such point has not been raised.
All subject matter. language is there. Section 3. Affairs of the state. Yeah. And they are claiming to the interest of state government. Who can serve this as a part of the party? Then other the party.
No. May I just submit one thing? No. Mr. Mukherjee, on the very outset, verbally raised this point. After long time, court considered that along with the merit, that point will be. And practically speaking, when I joined in the bar, I was against Mr. Mukherjee appearing. In other matter, he cited similar judgment, and he also supported that judgment in favor of him sometimes. So it is, he will show, I know. This is not a bar to him to show, but let this judgment be analyzed and how far it is practicable for this adjudication of this case. That to be explained. That is why I called it on merit. Well, kindly come to page number 91.
No, they are the state government employee, admitted.
Contractual.
Contractual employee. So they are associated in the affairs of the state. The word affairs of the state was also issued. A administrative tribunal act ache.
Kindly come to the.
Now, although Mr. Mukherjee is saying jurisdiction cannot be curtailed. 226 jurisdiction cannot be curtailed by the.
Here, my lord. My lord. L. Chandra Kumar.
But in view of the judgment of L. Chandra Kumar,
I will cite.
Yes, the recruitment and matter concerning the recruitment of to any post, service of post, in connection with affairs of such local authority and a corporation, and the state also.
Thereafter, one after judgment has been passed. Then all the judgments should be set aside passed by the High Court. It will be held per inquirium if Mr. Mukherjee's proposition of law is otherwise correct.
That is not the answer.
That is not.
That is not the answer which may come from a learned person.
Now, yes, madam.
Learned person will come. Yes, this issue has been raised, but it is the appropriate answer. Okay.
That is not concretized.
That should not be the.
That is not
so all
concretized.
judgment passed in this matter should be set aside. That would not be the proper argument according to me, subject to
Yes,
that.
my lord, definitely.
Okay.
Correctly. This was
you come with the judgment, L. Chandra Kumar.
No, I have come to know, but after L. Chandra Kumar is the old fox. After that, the new judgment has been passed day after day. One is Uma Devi, 2006 it was
that
passed.
Is regularization.
Directly approached. Because my lord, lordship appreciate rightly that High Court's power, 2026, if there is a violation of the law, because Uma Devi was set up as a law. All the judgments is otherwise either this side or that side coming from the Uma Devi. Uma Devi proposed two principles of law. If the appointment is irregular, can be regularized. But if the appointment
is the merit of this
merit of the matter.
Regarding maintainability of the writ petition.
Due
to existence of of an alternative and statutory remedy available before the tribunal. Whether this writ petition should be entertained or not. Particularly in view of the judgment of L. Chandra
Kumar said,
as Mr. Mukherjee's
sides.
saying or is claiming.
All sides. Same judgment. I have.
What is your answer?
Answer is that L. Chandra Kumar case is that when the tribunal has been created, State Administrative Tribunal or the Central Administrative Tribunal, if it is a matter related to the recruitment, that is a fresh recruitment. Our case, we are continuing the service on contract for 20 years or more, and now, my lord, we have been victimized with a pay scale of a group D staff. My lord, that is, my lord, answer well answered. It is not very much vivid or distinguished in this provision of law that whether there is any particular demarcation or the reservation for the contractual employment, or it will generally carry the whole thing as it is.
Most probably answer not got. Whether your tendency of argument says whether the regularization would be kept outside that tribunal or outside the decision of Chandra Kumar.
In that case, my lord, my answer is
In the affairs of the state, service in the service related dispute, maybe regularization, disciplinary proceedings, maybe appointment, maybe promotion, it all be dealt with by the tribunal now.
Now, if it is so, but my point to be raised at the very initial.
One thing that it has not been raised at the
any point of time, even
earliest possible opportunity.
Even
I
in
have
their-
pointed out that thing.
Yes, ma'am.
Now, whether if it is point of law and point of jurisdiction, and
That should be Mr. Mukherjee will
says point of jurisdiction, it can
will
be
enlighten us.
raised even Supreme Court in SLP also.
He will enlighten us on this point. I will try to cope up the story. My lord, let me proceed with the other merit of the matter. Then on the next occasion, we will come.
First, court, if the
Yes,
issue of mental
My lord.
impairment is raised,
My lord.
a court should resolve this issue first before proceeding further, I think.
Rightly observed.
Mr. Mukherjee, what about Rothar Matthews? Rothar Matthews, 2020. Your L. Chandra Kumar, 1997.
97 3 SCG, page 260. Has been considered by 2010 4 SCG, 53, and 2010 SCG online 390. Anjali Mukherjee was the Commissioner of Police, Calcutta.
Now, whether this issue can be raised at the final stage of hearing?
At any stage.
Why is that? Judgment at any stage? If you say it is a question of jurisdiction, then it will go another.
Only jurisdiction question.
Jurisdiction, I am not agree with that, with you. Jurisdiction cannot be 226.
Has not been cut by the Supreme Court or by the High Court.
A basic feature of the Constitution. You know, various judgment and being a law, either in the Parliament or state legislature, you cannot take away the power of the High Court to issue writ. You know better, very well better.
Why addiction? Why 226? Article 226, but unconditional the High Court that has been decided by itself. I'm not disputing that opposition and certain. Number two. Paying for regularization against state government. That means affairs of the state. If it is affairs of the state, whether matter.
Write it, okay, to paste into judge, you write the judge. You let your junior write, you submit. Let your junior write, you write the citation and give it.
What they are fair. And they should regularize the state government employee. But for a moment, section 50.
Yes.
15. Sorry, 15 subsection. All service matter. What is the service? Affairs of the state concerned appointed to in service of post because he being a person whose service are in place by such local authorities, corporation, society, control of what person.
Yes, book is with me. Yes.
What is the service section? Mediation to person makes all matters constituent body in connection with affairs of the union or of the state, affairs of the state. You are discharging state function or any local authority or other authority, the territory of India or under the control of the government of India, or as the case may be, or any corporation or society by the government, this remuneration including allowances, pension and other benefits, tenure including confirmation, seniority, promotion, reversal, retirement, supervision, leave of absence.
Yes, I got it. I got it.
Whatsoever.
Yes, I got it. He should have approached the learned tribunal.
Yeah.
Now you can raise this issue at the final stage of hearing. You show this. So you show that judgment. You have not raised this at the time of admission of the writ petition. Admittedly.
AIR 1954 64 page 4.
AIR?
1954 64.
Huh. Okay, AIR 1954 Supreme Court page 340. Paragraph. Quorum not judice. That is another aspect.
Another thing. Non-juris mean there is a.
That is, again, I am saying, quorum non judice, whether you will be able to raise. It is not a question of jurisdiction.
Right to raise the objection at the final hearing of the writ.
It is you, Roger Matthew judgment you will find, and there is a Union of Indian Redappa 1993. 1990. 1993 volume 4 SCC page 269. Once the court is satisfied that the injustice and in arbitrariness occurred, any restriction, whether self-imposed and statutory, stand lifted. And I am saying the Roger Mathur judgment. Roger Mathur, Matthews. If you read the author Matthew's judgment, the concluding part, we will find the Supreme Court state that it cannot be stated to be an alternative remedy at all.
Alternative remedy that I can describe by Justice Bhattacharya Bhattacharya. You take that in.
Yes, Konok, Simoti and others versus UP Avasivam 2003 volume 7 SCC page 69. If you can't raise the mentality at the earliest possible opportunity, you cannot raise this at the final stage of hearing. US 2007 judgment, division bench, what is the proposition?
Proposition of whether you can approach the report as a by alternative remedy. But kindly see all the judgments of the Supreme Court.
2007.
2007.
2007 SCC অনলাইন আর কোথাও নেই
2007 CHN আমার আছে।
তাহলে পেজ কত? হ্যাঁ বলুন না একটুখানি, নাহলে খুঁজে পাবো না তো।
Two thousand seven, 3 CLT Calcutta times 456.
2007 বলুন
3 Calcutta.
Yes, yes, you read that paragraph 10. You read, Mr. Banerjee, you read paragraph 10 here and now. Hey, yeah, din to eta onake.
my lord.
That would have been considered.
But I am not agree with this whether it is binding upon me. There cannot be stated to be ouster of jurisdiction.
Ouster of jurisdiction because of this act. Now,
I have some reservation in using this language. And I am giving you
Section 28.
ouster of the jurisdiction can be stated of a civil court.
Now, ouster of the jurisdiction of the
Civil court is a court constitute under a statute, not under a constitution.
Yeah.
And constitution means that apart 226 article 32 Supreme Court repeatedly and larger bench constitutional bench repeatedly stated it is basic structure of our constitution. You cannot curtail this power.
Yeah,
it is basic structure.
That has been said by H of the court that by as a first instance that has been again referred to the Justice Procedural and Justice HON'BLE on a paragraph 10, 12 and 16. But
কপি হবে কপি একটা করে দেখতে পারি এত আছে কোনো
রিপোর্টের জায়গা
না বলুন তো আমাদের কাছে সব 2010 554 আর একটা সব করে বলুন আমি লিখে
1997 3 SSC page 260 260 54 Supreme Court page 340 ওই CHN
সিএলটা কত বাবু? সিএলটা বলুন, সিএলটা কি আমি বুঝতে পারলাম।
Because of section 28.
Yes.
Jurisdiction of the
Roger Matthew versus South Indian Bank Limited and others. 2020 volume 6 SCC page 1. Okay.
2020
volume 6 SCC page 1. In L. Chandakumar case, it was clearly held that right of judicial review is a part of basic structure of the constitution. This right must be interpreted in the manner that it is truly available to the litigant and should not be an illusory right.
Yes.
And self-imprisonment bar and
but this has been again clarified in paragraph 93. We may add that tribunals are however continue to act as only courts of first instance in respect of areas of law for which they have been constituted. The Constitution bench explained the statement of the DI in next sentence in Chandakumar by we mean that it will not be able to the litigant rather to approach the High Court in cases where the question varies of statutory legislation except as mentioned legislation is the particular challenge.
Yes.
The judiciary of the tribunal concerned. On proper reading of the above two sentences clear, the tribunal function of the only court of first instance in respect of the areas of law for which they have been constituted. Even where the challenge is made with the varieties of legislation, except in the legislation of the tribunal has been set up. Such cases also litigants not able to directly approach the High Court, overlooking the jurisdiction of the tribunal.
Which judgment?
2010 code.
হ্যাঁ
This is quoting from H. Chandra.
ইয়ে
Then analyzing.
larger bench. I am saying I am just reading one line from Rothard Mechur. The alternative remedy of approaching a tribunal is an illusory remedy, not an efficacious alternative
Division
remedy.
bench, if my lord wants to.
The
refer-
self-imposed bar or restraint on of an alternative efficacious remedy would not apply.
But
Now
our
you go where you will go.
our division bench, Justice Bhatt.
You consider the Rothard Mechur judgment and you all collect the judgment. You read,
I will read.
consult.
I'll find.
And I am also giving the Rothard Mechur judgment also to you. You should have come with the judgment. Now it
Only
is,
thing I can.
beauty has become reversed.
Only thing I can say that in the no provisions of this particular tribunal act, no
So
nothing.
Rothard Mechur judgment in the context at that time, tribunal was not functioning. And that
And he, Malan,
considering this conduct, the tribunal they have set up, but they are not giving the judge.
One thing may I just.
They are not giving
At least for that.
administrative.
One thing may
So you cannot deny justice to your citizen.
Nobody can try.
One thing may I just submit, my lord, that is, my lord, if I go through the scheme of the act, legislation, entire scheme, it is all related to the employment, then their remuneration, their pension rules, we have nothing. We are not having.
Mr. Banerjee, I express my mind. I express again, I am saying, if the respondent raised the issue of maintainability, the court is to address the same first. Mr. Banerjee, without going into the merit. It's the duty of the court. Maybe I have stated everything. I have not, kept something concealed. I am what I say. I am a bad judge to say yes. I say everything.
There is exchange of ideas.
So he has not raised this issue at the earliest possible opportunity. Okay, he is raising this issue at the final stage of hearing, whether he will be debarred or not. Okay, and he is saying that it is a question of jurisdiction. It can be raised at any stage of the proceedings, even before the SLP also, before the Supreme Court, at the time of hearing of the SLP and civil appeal. Whatever may be. It is his submission. And he placing his reliance on a division bench judgment 2007. He is saying that it is a nothing but a ouster of jurisdiction. Okay. Although I am not agree to this, I am requesting you to consult with the L. Chandra Kumar, Rothard Mechur, and many other judges. Okay. And I am also saying that Kobita Konok judgment. Konok judgment that 2003 Konok Simoti. I gave it to you. Konok judgment. Yes. Konok within bracket Simoti and another versus UP Avas. Ivan.
UP Abbas.
UP Avas Ivan Vikas Parishad. 2003 volume 7 SCC page 693.
My lord.
The issue of maintainability, if not raised at the stage of admission, he will not be able to raise it. Okay. Heard the learned advocate appearing for the respective party. Exchange by the parties are taken on record. ঠিক আছে, heard the learned advocate appearing for the respective party, leaves the matter for further consideration at 2 PM যেদিন ফাঁকা আছে দিয়ে দিন, ধক দূরে। ওদের 60 বছর পর্যন্ত চাকরি আছে, সুতরাং ওদের অত এফিডেভিট ওরা একটা দিয়েছে, দুজনেই দিয়েছে, দুপক্ষই। হ্যাঁ, কবে ফাঁকা আছে? 21st August, হ্যাঁ, 2 PM
21st
next
August 2 PM.
Yes.
Step number 11.
11, yes.
I'm for the state, my lord.
My lord, my affidavit in reply.
My lord, the affidavit of exchange of affidavits, this matter pertains to transfer of online transfer matter and exchange of affidavit of exchange, my lord, complete. This matter actually take up by his lordship, the Honorable Justice Shogata Bhattacharya. He was heard this matter about the, my lord, the online application of Usosri portal under the transfer. That time, the online application was closed and suspended. And what is the present status? That's why his lordship.
Where is your affidavit?
My lord,
We have filed, my lord. We have filed the
Yes,
affidavit.
got it. Respondent number 7.
Pardon me, my lord.
Respondent number 7.
Yes, my lord.
State is not there.
Yes, my lord. State is represent respondent number 7, the ASE.
Who is respondent?
Assistant Inspector of School.
District Inspector of School. Okay.
Yes, my lord. On behalf of District Inspector of School, they have filed the affidavit in opposition and they have filed the reply.
my lord, here I am challenging the
Order of the DI. Annexure P10, page.
page 46.
46. Yes, this chamber transfer of all eligible teaching associates has been processed through the online portal and as per notice of the portal has now temporarily under temporary suspension. Okay. I have passed my passed order on
My
this.
lord, division bench also decided the issue.
My lord, so far this matter is
Because, my lord,
in his petition, my lord,
only
kindly in page number 48, page number 48, এক minute, বলে দিচ্ছি আমি।
He will file offline application, consider whether this application can be accepted.
offline already
But
filed.
till that I have just stopped.
Filed and page 46 passed an order on the basis of my offline application. Page 46 passed the order as per my offline application.
My lord, there is a
online application already in earlier occasion, online file that was rejected only on the ground that the distance between the school that was 25
kilometers, which
because
is
here
not beyond.
তুমি আমি দুজনে বললে তো মুশকিল
ঠিক আছে।
because here I am my application for transfer made under 4A1 for 1A. If your lordship kindly see for a moment, page 48, the scheme which I annexed. They rejected only, my lord, 4(1)C. I made application, page 48, kindly see for a moment.
48, thereafter
4(1)A. My application is this.
4(1)A, all nursing staff suffering from malignant disease.
And procedure, page 53.
No, they have rejected.
On the ground of, my lord,
they are rejected on the ground that the distance in between the school and your.
No, offline application rejected only on the ground that Utsorsi online portal is now under temporarily suspension for processing of online transfer prayer till some period as per notification of the Deputy Secretary to the Government of West Bengal School Department such and such. As Utsorsi portal is temporarily on suspension, that the reason only rejected my offline application. But here I am showing before your lordship the division bench that judgment that only suspension of Utsorsi portal that does not be a ground for rejection my application on transfer under medical ground. Well, this is the judgment passed by this Honorable High Court and division bench.
Now, where the online application,
yes,
where the provision that online application is to be made.
Online application subsequently, my lord.
No, where the provision you that March 11 circular, where is that? That one person is to apply or through online.
My lord, online application at that time I made online application. Date online application. Suspended.
You are not. Where that provision that online
application is suspended, my lord. Suspension of online.
Suspension subsequent. Where the application in the rule.
Application for my lord transfer.
Online, that one
Online
person
application.
is to submit an application through online.
তুমি যে অনলাইনে অ্যাপ্লিকেশন করেছো সেই অ্যাপ্লিকেশন
That provision, where is that provision? Whether it included in the
Transfer application 15 April.
or it came subsequently.
8 September amendment maladai yani. Procedure maladai annex page 53. Page 53. Yeah, 6-7. Page 53 I annexed. The procedure for general transfer special ground under 41A. Page 53 7 rule 7. হ্যাঁ that also
জেনারেল ট্রান্সফারের ক্ষেত্রে
that also
ফর
annexed.
জেনারেল ট্রান্সফার
Page 61 my lord the amended provision.
হলো ইটস নট জেনারেল ট্রান্সফার
6.
Same thing. Same thing. I held in my one judgment. I have a judgment. It is a procedural tool. This is a procedural tool. The act or such and such whether the notification is called which rule?
My lord 2015.
2015 rule. It has conferred a substantive right. It cannot be taken away by any procedural law or change of procedural law or due to this continuation of any procedure, online procedure, offline procedure. That right. You have conferred a right that in case of fulfillment of any of the condition, one teacher has a right to seek transfer either on general transfer or on special government. It is a substantive right. Now you cannot say, okay, you cannot say that since I have suspended the Utosri portal, your right gone.
My lord, may I submit one thing? Actually, my lord, may I submit? My lord, pardon me. May I submit one thing? Actually, this transfer application is allowed by the school council, and school council is the party in these proceedings. They have not appeared. Actually, DI have.
Okay, I've got your point. Yeah,
DI have.
the patent has been prepared.
I will move this matter.
Yes.
Only for the reason that if I don't move it and pray for adjournment, matter will go out. So
No, no, not that.
except that I will give a
I have given outline of the fact of the case, but I shall not conclude the hearing today.
go down.
Yes.
But what is to be termed as a fraud? What is fraud? Well, okay, don't open the brief. Can you hear me for 2 minutes? Bank issued a notice for sale. 6.31 is the quantum of land. It is said as is where is the value of this. We pay the entire money. When we try to take possession, it appears to me that the part of the value, 50% of the sale notice quantum of land has been sold out to somebody else prior to this issue of sale notice. Yes, Technical Court Authority, a State Bank of India issuing a notice for sale of a quantum of land as is varies basis, out of which 1% has been sold out prior to this date. Even they were not
Sold out by whom?
bank or maybe the borrower. That was thought to be sold out, and I rely on their promise. I should say is a promise that he can pay and get the land. Can they take advantage of as is varies basis? As is varies basis, he can be that is a tenanted. I see that. Oh, 1 decibel of land is enclosed. I don't understand. It is not the owner even. That has been sold out to me. I am not getting the possession, and they are not issuing the sale certificate of 50% of this one also.
They have issued sale certificate in respect of 50%.
No, that has also not been done. Entire payment has been made. Peculiar. For a glimpse of this matter, can you see the sale notice, page 56 of your lordship brief? Peculiar. Tell you, page 56 can is the column as well. Can 3.
Which for the bank?
My lord, it is bank, no. Oh, bank, yes. That has been.
Assets restructuring company.
It has been.
But who is the bank?
But now the bank has.
Now the entire responsibility.
Signed the degree in his favor. Now, my lord, can you come to page 56 and strain your lordship's eyes? There will be some strain to read it.
Property 1, 2, 3, 4. What is your property? First one, yes.
Come to the third column. Last year, you will find 6.20 kata. 6.21 kata. Has Mother got it? Nothing else to be read. And
First row, third column.
Yes, first row, third column.
Deed number 1076 of such and such, 1957.
Come to the bottom.
Bottom 5.9. Yes.
6.21
kata. Yes.
Got it? Then, my lord, I am not. Please tell it. Record the date. 1st January 2014. And now.
Date of auction.
The advertisement.
Oh.
After this filing of this writ petition, we searched out and came to learn the 50% of the property has been sold out. That document I have annexed. Kindly come to page 132. 132A is the, my lord, English version. 145 is the schedule.
132. Yes.
Start. Can you come to the schedule? While we will look at the schedule only. 145. 145A, can you see this is clear? 5 by 5 is 6.
Yes. All that 2 stories, 2 room brick build, tenement and such and such.
Khana Sampur, Khana Sampu.
Hmm.
26 by 1A, Balaram Hostik. Fellows got it?
Containing an estimation of an area of 2 kata, 7 chitaks, 18 square foot.
That has been sold out.
Hmm.
Can you see the date? 132, no? 132. 23rd May 1983. Prior to issuance of the sale notice.
Hmm.
Thank you. If selling, my lord, kindly come to page 134. Sandeep Seal, Sandeep Seal. Sandeep Seal. They are the borrowers.
Hmm.
Heading 2. Shiva Bhattacharya.
Yes.
Now once you can go back to 56 to tally. Now kindly come to the first column.
Hmm.
Sandeep Pal, Sandeep Seal,
Snare Cloth Merchants Private Limited.
plot of land, auction, which has been sold out prior to issuance of the auction.
Hmm.
That part is clear to my on the document, no evidence, nothing, not necessary. I have paid the entire amount and paid it back. Not getting the possession. I could have understood 50%, they have sold out prior to that. So 50% I should get. But condition is you have to pay the entire amount. They are not going to refund you. You may think that I have not gone through the entirety of this bill. This is an outline of this.
What is your defense?
The submission is there was direction for affidavit in the main petition. Now this scan fee has been filed disclosing new documents which were not part of the petition. So let me deal with this in the form of an affidavit. The CAN application. My defense finally was with the
It is the writ petition of 2016. Already 9 years.
We had submitted our affidavit in opposition in 2016 based on the case made out in the writ petition. Now they have filed a CAN fee.
That document was not with
new documents. It was sold on as is where is basis. Inspection was granted. They were clearly aware how much portion was in actual physical possession. We have gone under the procedure of the SARFAESI Act. They had alternative remedy before the DRT. They have not availed that, my lord. I will place my lord on
this
the
is
fact.
called in Bengali, my lord, Chorer Mayar Borogar.
But I'll
A property which is not the owner of the bank has been started to sold out.
My lord, in the valuation
Induced me
prior
to deposit the entire amount.
Where is the provision? Where is the provision like Order 21 Rule 89, Order 21 Rule 90 in SARFAESI Act?
Under the SARFAESI Act, if any person is aggrieved by any measure, I'll show those judgments.
In respect of any auction sale, it is found that there was a fraud.
Yes,
the civil court had addressed the issue. Where is that provision in the SARFAESI Act? That Debt Recovery Tribunal will proceed under SARFAESI Act. So here is the provision of your SARFAESI Act.
My lord, my submission is in the writ petition there is no
Rule 9, most probably Rule 9 of the SARFAESI rule. Where is the provision?
It was not sold to me.
Where is the provision? You say that there is a provision, or you have to show that there is a alternative efficacious remedy available to the petitioner under this statute. Then you can invite a writ court to exercise the self-restraint or self-imposed rule. Okay, but where is the whether the remedy is efficacious? So
several judgments, series of judgments of the Supreme Court that even an auction purchaser aggrieved by any measure of auction sale by the bank can approach.
Yes, can approach. But in this case, how the alternative remedy is barred here? There is no evidence to be adduced. Straight away the practice fraud on a citizen.
My lord, this is the judgment of the Honorable Supreme Court, Agarwal Checkom.
Yes, I shall bring Rother Matthews. 2020, volume 6, SCC. Supreme Court says this is illusory.
My lord can consider all these issues. What I am submitting
Ah.
today, there are new facts. I have no instructions on those facts.
Like just submit your served on sometime in
When it was served?
It is 2023, 10th October 2023.
But there is no direction for affidavit on this.
My lord, what is the suit court? Direction necessary for filing written statement.
My lord, where there is direction in
So come with it is unfortunate. Unfortunate. I on the next date I stated that actually it is being done. The person who after conducting a search submitted the report to you, that person, your employee who disbursed the loan, now you are going on defending
my lord,
their action.
That I cannot defend because my lord, I was not there.
You are doing so. You are doing so. The person whom you entrusted with the job of conducting a search regarding the land, that search report is a fault. There is a fault in that search report.
But they could also, it's as is very sale, they were given the opportunity to do the search. If it is a registered document, they could have done the search and found there is another sale deed, my lord.
Okay, I shall penalize them. But before that, you have created a collateral security in that property. In that property first, you have given them the loan of a public money.
That, my lord, kindly
Okay, of a loan. You are a public bank. So that you are dealing with the money which is public money.
I appreciate.
Appreciate. So you have given the money. When the question of recovery of will come, then you will come. It is a public money. So what State Bank or what bank is doing? It is your money. It is Mr. Bose's money. It is money of all of citizens. Yes, it is my money also. It is my money also. You are entrusted to deal with such money. Now you, based on a false searching report and your officer or person concerned, I don't know what was the consideration, has granted the loan.
My lord, kindly call, because I am telling my lord, because we are asset.
Okay, so Mr. Bose, I am inviting them there since they are thinking that they are going to be deprived.
Original retracement affidavit not filed up till date.
We have served the affidavit in opposition.
If it is served, I have nothing to say.
We have served.
On record.
Affidavit in reply is there.
If there is, you are not having a copy? No, again.
Affidavit opposition on behalf of respondent number 3 and 4. It is on record.
My fault.
Okay, so you come 1 week, 2 weeks.
Stop.
Number
1, because that is the bank. They have to answer if it is a fraudulent.
If they don't answer, we have served.
I might give the opportunity to them also, because we can only say after taking over the law.
They are not seeking that opportunity.
Pre-auction, they cannot
only deal with anything
post-auction.
My lord, when
you cannot say.
loan was disbursed.
Acha, heard the learned advocate appearing for the respective parties. Acha, stop. এই এটা
My lord, I was engaged before other courts, so I could not come in time.
আচ্ছা ওরা না স্টেট ব্যাংক অফ
State
ইন্ডিয়া
Bank and
ইউ ফাইল এফিডেভিট
already filed, my lord, in the year of
in respect of the application being can 3 of 2023. Just I have given dictation and hence it is still in my mind.
actually the thing is that, my lord, now already the account has been assigned to RCIL. Now State Bank is no more in picture.
By filing affidavit, you say so?
Yes, my lord, already I have.
Because ARC has stated that the affidavit from the State Bank is also necessary.
Yes, my lord, that has been filed in the year of 2017, my lord. 2017.
To the writ petition.
Yes, my lord, where I have State Bank has stated that.
Okay, so he does not want to use the affidavit.
Already I have stated.
Okay, come on that day, 3 weeks since.
3 weeks since.
3 weeks since. The ARC has taken time, we have 2 weeks to file affidavit in opposition. 2 weeks, 1 week. They will file reply 1 week, 3 weeks. Come after 3 weeks.
My lord, my name may
Your name will be recorded. বড় বড় করে লিখে দেবেন। Bold letter.
Not that, my lord. Otherwise, it may.
Okay, yes, I have got the point. Yes, yes, Mr. Chakraborty. Yeah. Then.
My premises situate upon the embankment of a pond, my lord. I have made the
Take adequate safety arrangement while excavating the pond so that the structural stability of the petitioner house, such and such, is not affected.
Yes, only my
You have constructed a house on the embankment.
my lord, that has been made, my lord, when my lord, with due sanction of the authority, and it my lord, the embankment due to passage of time.
West Bengal Inland Fisheries has, have you bought?
No, my lord, it is not in the wasteland. It is in the village.
West Bengal Inland Fisheries Act.
Those are not coming into, my lord, play here, my lord. Here what happened, my lord?
Mr. Chakraborty, I am.
Pond was, my lord, excavated. Pond was there, and my lord, due to, my lord, Mahatma Gandhi National Rural Guarantee Scheme, they made further, my lord, removing of the earth. The building is there, my lord. I am the permanent resident of that village. That is my lord, ancestral property. I am living for generations together in the village, and I have the construction is made with the sanction of the, my lord, Panchayat authority, my lord. My lord, thereafter the pond has been, my lord, the earth has been removed. Thereby, due to the removal of the, my lord, earth, my guard wall has been affected, my lord. Some portion of the building has been leaned towards the pond. My lord, for that reason, I filed a previous writ application. That writ application was heard in presence of both parties, and that was heard by Honorable Justice Somapti Chatterjee. My lord, on hearing, her ladyship was pleased to, my lord, pass an order, my lord, directing for inspection by the PWD executive engineer and to take effective steps. And BDO was, my lord, BDO of the concerned, my lord, block was asked to, my lord, take effective steps in terms of the report of the executive engineer. But unfortunately, my lord, executive engineer did not make any inquiry, nor nor steps were taken. Rather, by an assistant engineer at the instance of the PTO, my lord, made an inspection and submitted report that no further steps are to be taken. My lord, thereafter I filed the instant writ, my lord. In the writ, my lord, the matter was agitated before previously before Honorable Justice Samapti Chatterjee and subsequently before Honorable Justice my Lord Kapoor, my Lord. His lordship was pleased to direct to make an inquiry. And thereafter, my Lord, an inquiry was made. My Lord, after inquiry, my Lord, report was filed by the executive engineer. My Lord, that will be reflected from the report my Lord, that report has been filed, my Lord. That my Lord, I have filed that report. Your Lordship will find that the report is appearing, my Lord. Kindly see the report, Your Lordship. Kindly see Honorable Justice Kapoor's order and the report of the executive engineer. My Lord, what I am praying for, my Lord, the steps may be taken for, my Lord, safeguarding my property, which has been, my Lord, damaged, which has been occasioned due to the removing of the earth in terms of the report of the executive engineer. My Lord, I am not innocuous order, my Lord, it will not affect anybody. But my property has been damaged at the instance of the, my Lord, some state machinery, my Lord. So I am entitled to, my Lord, kindly see the report of the executive engineer.
Where is the report?
My Lord, that is, my Lord,
executive engineer will not our purpose. Who is executive engineer? It is had it been a public road, executive engineer come, public land, DM would come, fact finding authority. Here, Department of Fishery will come, collector will come. Question whether you have converted 4C and Inland Fisheries Act. West Bengal Inland Fisheries Act, have you brought?
I have not touched, my Lord, I have not touched the pond.
My Lord,
I have done nothing.
My Lord, I would
It has been done by the state machinery.
My Lord, I would invite my Lord, 2 lines of his written submission. My Lord, page 4, para 4.
Written submission.
Written notes of
Coordinated heard this matter extensively. Written notes of arguments were submitted on
Submitted.
behalf of the
Petitioner.
and the other parties. Thereafter,
written note.
change of determination.
Where is the written note of sir?
We have been served with a copy of
written notes, my Lord, is also there, my Lord.
এই দেখুন তো এটা রিটিন নোটস কোথায় আছে? এটা তো হচ্ছে একটা, এটা রিট পিটিশন, a short note of argument.
Yes.
Yes.
My Lord, on behalf of the petitioner. Page 4, para 4, last 2 lines, last 3 lines. I'm coming on that issue, my Lord. Page 4, my Lord, got it? Page 4, last 3 lines. Though your petitioner had duly constructed a Paka concrete guard wall about 60 feet length and 12 feet height to protect his building. So his case is he has constructed 60 feet length, 12 feet height concrete wall. And my Lord, kindly now, my Lord, this circular of West Bengal government that has been recorded in an order of the Honorable Guwahati High Court. I did not find the circular, but the entire circular has been reflected in the order. My Lord, may I hand over the is in the judgment. I've given the, my Lord, it has been entirely quoted. It is, my Lord, Department of, my Lord, kindly come to page
Department of Environment.
Yeah, page 20. And my Lord, relevant portion is page 22. Clause Roman 5.
Yes.
Top. These are the restrictions. To protect the water bodies from encroachments, erosion of boundary, erection of boundary brick wall around a pond should not be undertaken. So, admitted case is he has constructed Paka boundary wall. 60 feet length, 20 feet height, 12 feet height. It is against the, my Lord.
My Lord, state has not come forward that I have made any illegal act. My Lord, here, my Lord, I have filed
it is completely against the, my Lord, the statutory circulars issued by the
my friend, I suppose, is not appearing on behalf of the state.
Whether he is owner of the pond?
No.
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 My lord, I have not touched the pond. My lord, my premises has been endangered due to the removal of the earth. Lateral support has been removed. Lateral support have been, and that will appearing from the report. Previous writ petition filed and subsequent writ petition also.
Mr. Chakraborty, now you forget about the pond. Now, as per the stand of the state, you even cannot touch the embankment of one pond.
Yes.
I have not touched.
Because
not-
embankment is only to protect the pond,
My lord, I have
not to raise a building there.
No. My lord, what happened here, my lord? Here,
The reason has
my lord,
been, my lord,
if- my
reason
lord,
has
if
been
my-
quoted
my-
in the paragraph
No,
5. I have referred.
my lord, I have
Because
not.
the natural, my lord, kindly read paragraph 5. Entire thing has been recorded.
My lord, building has been made.
Whether they have issued any order,
My lord, who?
authority concerned.
Authority concern, no. My lord, kindly see, I myself filed writ petition, earlier writ petition, my lord, kindly see. My lord, kindly see page 55. First of all, kindly see page 55. This is the previous order, my lord. Page 55 of the writ petition.
And that bill,
Page 55.
public interest litigation has already been taken on this act.
Private dispute.
No, not at all. Private is not.
Owner of the pond is the private respondent.
Owner of the pond has not done it. It has been done by the Mahatma Gandhi Yojana by the Panchayat. Owner has not touched. It has been done by the Panchayat authority under the Mahatma Gandhi Rural Development Scheme. That has been done by the fund has been provided by the government. Owner has not done. My lord, kindly see page 55, one by one. Yes, my lord. My lord, kindly.
Pond is the private respondent.
My lord, kindly place my case, my lord.
Actually, Mr. Chakraborty, is a question of fact is involved. So at best, I can refer the matter to the DM, who along with the Department of Fishery, any representative of the Department of Fishery, may inspect
Your lordship will do.
whether you have violated the West Bengal Land Reforms Act by way of conversion of the nature of the land and user of the land, or whether you have violated the provision of West Bengal Inland Fisheries Act.
Also, my lord, relevant circulars and
your lordship will
circulars.
do it, my
Because
lord.
the
Whatever
circular
your-
itself, I have referred, my lord. It has said, my lord, the concrete boundary wall should not be permitted to over the pond.
Whatever
And his admitted case is, my lord, he has constructed. Sir.
Whatever reasonable your lordship will do it, my lord. Before that, kindly, my lord, allow me to place my case. My lord, kindly.
It is.
5 minutes, 7 minutes extra.
You have adopted resolution.
Then, my lord, no allegation is there against me up till now. My lord, I have not been issued with any circular or notice by the government or my lord any violation regarding any violation of. I came before your lordship by filing previous writ that has been decided in my favor with a direction upon the state authority to do something that has not been done. That's why I filed the second writ. In the second writ also, my lord, order has been passed to make inspection and to submit report. Report has been submitted. Your lordship will take into consideration of the report.
What report? What report?
Yes, my lord, kindly see.
Tell what in the report.
So kindly see the order, my lord. Order dated, my
In the
lord.
report,
Second of September, second of July 2019, my lord. Kindly see. 2nd of July. 2nd of July 2019, and then, my lord.
2nd of July. No, 2nd of July.
2nd of July 2019, and thereafter 25th of November 2019.
Order গুলো কটা রিপোর্ট হয়েছে? একটা রিপোর্ট না কটা রিপোর্ট?
রিপোর্ট তো একটাই হয়েছে। কোর্ট has expressed his, my lord, displeasure for not acting in terms of the order, and thereafter, my lord, order has been passed on 25th.
It was sent to the executive engineer, PWD.
Yes, thereafter, my lord, 25th November.
From his perspective.
My lord, 25th November, your lordship seen.
It should be better to send to the collector as well as to the Department of
Another
Fisheries.
round of litigation, another round of litigation.
Appropriate authority, the appropriate authority who should be, who should. Engineer should consider about the building.
Yes. My lord.
About the building.
But with regards to the water body, its environment,
yes.
district engineering কি একটা আছে না?
Environment,
Environment department, district.
My lord, I think my lord, writ
engineering-
petition may not be disposed of, your lordship past a direction, and then my lord.
No. That would not.
Otherwise, my lord.
I am fixing another date of hearing. The
All right,
matter will be
all right.
matter will be referred to, remitted to them. They are the appropriate authority, Department of
Yes.
and to speak the truth, they will find out. If it is find out that you have not violated any, they will pass appropriate
My lord,
order or allow you to take protective measure.
Protective measure.
Yes, protective measure. Yes, I have understood. So I am not passing this order today. Today is no time.
As your lordship.
I am fixing another date. Okay.
As your lordship.
Further learned advocate appealing for the respective party leaves the matter for
It has been quoted. I tried to find out.
It may be lost from the record. Yes, you may come with another copy.
Record it. The circular I have relied.
The document as produced by